Okay, good morning, everybody. It's just gone 9:30, and welcome to the scheduled hearing for stream number 5 to the proposed Lower Hutt District Plan dealing with natural hazards, the coastal environment, including coastal hazards and definitions and strategic direction objectives. Before we commence, I'd like to invite those who are able to participate in the karakia that you'll see on the board in front of us.
Tuia timana aki aki, rarangehi te mana rangatira, kia tipu kia puawai, iripo nawai, o tiawa kai rangi, he kaitiaki, ki te whenua, he oranga tai o, he oranga tangata, ho he huie tākie. Thank you.
Thank you, everybody. Could I also invite the hearing administrator, Saritha, to outline some of the housekeeping and health and safety procedures for the hearing this morning.
Thank you. If you're feeling unwell, please do not attend this meeting. The meeting can be watched live on our council's YouTube page. In the event of a fire, there are 2 exits from the chambers, one on the west wall and one on the north wall towards the balcony. On hearing the fire alarm, the democracy advisor will show you an assembly point, which is down through the exit at the back and towards the Rutherford Gardens. And event of an earthquake, please drop, cover, hold until the shaking stops, and then wait instructions from the democracy advisors. Please make sure all your mobile phones are switched off. And if you need to take a call, please, you are free to go outside and take this call. There are toilets on to your left from the staircase, and there's one downstairs as well. That's all for today. Thank you.
Before I get on to that, I'd like to take the opportunity to invite the panel members to introduce themselves, starting with Mr. Muspratt to my left.
Yeah, morning. I'm Matt Muspratt, obviously an independent commissioner and planner. I have worked as a planner in the consenting and primarily district plan and plan review space for 23 years or so.
Thank you, Matt. Commissioner Burge.
Kia ora, my name is Liz Burge. I'm a planner and independent commissioner based in the Wairarapa.
Kia ora, good morning. I'm Jason Jones. I'm also a planner based here in the Wellington region. And this is the 3rd of the hearings that I've been involved in this plan review process.
And lastly, I'm David McMahon. I'm the Deputy Chair of the Hearings Panel, but I've been asked to chair this panel in the absence of Mr. Lindsay Daish, who has to deal with some other matters at the moment, and I'm very happy to be asked to do that. Like my colleagues, I'm also a practicing planner. I'm based in Wellington. I've been in the business since last century. My focus in commissioner work has been on plan matters, but I also have been known to be involved in designations and resource consents. I'm particularly interested in planning process and the linkage between provisions. And my speciality is not hazards per se, but I'm very interested in how provisions give effect to higher order documents, and that'll be one of the themes of today's proceedings. Are there any procedural matters arising from staff at present? Mr. Geard, are there any matters that you want to draw to our attention?
No, there's nothing to draw to the panel's attention at this stage.
Okay, thank you.
Could I just mention that this session is being recorded, and if anyone has any concerns or objections, please do let me know. So this will be live streamed on our council website as well.
Yes.
Thank you.
And I understand that live stream will be loaded to the website.
Correct.
Correct, thank you.
Thank you.
Okay, the next 2.5 days are going to be perhaps a little bit pepper potted with breaks, given there's been some changes to the schedule in terms of people's availability. And I understand in that sense, one of your witnesses, Mr. Davis, is not available today. Dr. Litchfield, is that correct?
Yes, Dr. Litchfield's not available today. Edith Bretherton available today, also from Earth Sciences, who can speak to that. But Nicola is the expert in the modelling, and it's her evidence you've read, so she'll be available for questions later in the week if you have anything you want to put to.
Well, just on that matter, the panel does have one particular matter that we want to draw to Dr. Litchfield's attention, and it affects the submitter represented by Mr. David Gibson. Jason, do you just want to outline that?
I think Dr. Litchfield just noted that the spatial extent of the revised fault trace that she's recommending is her extrapolation only. And her recommendation is that the source data from, I think, Tonkin and Taylor be referred to, and actually refining that to a final degree. So I think we were just looking for perhaps some conferring between that submitter who might have that information to hand and Dr. Litchfield, hopefully with an agreed spatial extent that the panel can then consider. And the only additional matter that we'd like them to turn their mind to in doing that is just to have regard to any changes off the site at Benmore Crescent and whether that's within scope of what we can accept.
Sure, I can speak to a couple of points of that. I've requested that data from Mr. Gibson and provide it to Dr. Litchfield. I think my understanding is it does have enough information to do what she needs to do, but it needs some processing, so she hasn't completed that yet. In terms of the scope, my view is that the Te Kariaria Limited submission did not ask for this relief. And so there's no scope within their own submission for it, but there is scope within other submissions that sought the complete withdrawal of natural hazard overlays to do so. So there's no particular reason why it should be limited to the site. That said, Tonkin and Taylor's assessment was site-specific, so I don't think it will change the boundaries outside the site.
Thank you. And I guess just to clarify, we're mainly concerned about the transition points to look specifically at the off-site changes, not just what happens on the submitter's site. So I think it's more looking at the envelope and making sure there's no increase. Thank you.
We'll share that conversation with Mr. Gibson tomorrow, also just for the record. Before we get into the likely batting order, and I'll talk about that in a moment, I just wanted to provide a little bit of context for today's proceedings, and particularly to focus on the task that the panel has in front of them. Ultimately, we're going to be required to make decisions on these provisions that relate to the key aspects of the chapter, and that's the strategic direction objective, SDCC02, the national hazard objectives and policies, number of general objectives and a number of hazard-specific objectives. We're going to have to address the overlays, particularly the spatial extent and coverage of those, both at a district-wide level, particularly in relation to the slope assessment overlay, but also at property-specific levels. We're also going to have regard to the submissions on rules, standards and definitions. And the 42A report and the rebuttal provides the Council's position on all of those matters, and we're grateful for that, Mr. Davis. But before we land our decision on these matters, and having regard to the evidence not only of the Council but also the submitters, there are two key high-level matters that the panel are very cognizant of. And this won't come as any surprise to those that have read the background material, particularly a minute. The first is the extent to which the proposed district plan national hazard provisions are able to or should give effect to the MPS direction on natural hazards. And that brings into play the relationship between the RPS, Plan Change Number 1, and the MPS Natural Hazards Policy Guidance that came together in a recent consent order issued by Judge Semple. We'll come back to that later, but that's the first high-level matter that the panel will need to land. And the second, also one that we signalled in our minute, relates to climate change assumptions used in the modelling. And the issue here is, at least as I understand it, is that there is a recommendation in front of us from Mr Davis that the climate change scenario used in particularly the flood modelling and the notified plan be replaced with a, let's call it a less conservative scenario. And Mr Davis has invited the panel to give some guidance on whether or not the model should be rerun with that less conservative scenario. And that's a challenge that the panel is going to take very seriously. Both of those matters, the MPS and the climate change assumptions, are going to have a very large bearing on the decisions that we make on the provisions and submissions, and that's why we're keen to land those matters first. And as I said, minute 12 that we issued, I think it was on the 11th of this month, invited Mr Davis and Mr Quinn and any relevant submitters to advise us as to their position on those two matters. We have received rebuttal evidence from Mr Davis on Thursday of last week, or Friday, and we've received a memorandum from Mr Quinn also, and we thank you, gentlemen, for addressing those matters at short notice. Two important points to arise from that: the panel hasn't deliberated on any of those matters, and we haven't formed a view on either of these matters at this stage. We're very much an open mind on those. And secondly, our views will be influenced not only by what information we receive over the next 2 to 3 days, but our understanding of the scope available to us to implement the changes, and also the principle of fairness in terms of process. So that's the sort of context to today's proceedings, and tomorrow and Thursday when we hear from submitters. In addition to that, and on behalf of the panel, I asked Mr Davis to provide a mechanical explanation of the workings of the chapter in terms of the overlays and rules and policy direction, and how it works, and also the interrelationship of that chapter with the infrastructure, earthworks and subdivision chapters. And although I haven't read it, I think Mr Davis has captured that in his summary statement, and we're going to invite him to take us through that in a moment. The reason why I asked that is I wanted to be certain that, nonetheless myself, but also all panel members and submitters that are listening, understand how these provisions that we're going to be asked to determine actually work in tandem. In terms of that, we thought the probable and likely batting order that we asked Mr Davis to read through the summary statement, and we'll pose any questions that arise out of that. Most of the heavy hitting questions, though, will come later on. We thought then we'd invite Mr Quinn to speak to his legal memorandum. We do have some questions, Mr Quinn, on that. Then we thought we might take the witnesses' statements in turn, Mr Davis, and then lastly we return to the rebuttal and, if necessary, the 42A. I'm a bit reluctant to do a page turn exercise, but I know that the panel have some specific questions on at least the rebuttal and probably the 42A also. So summary statement, Mr Quinn, witnesses, then rebuttal 42A. Does that sit comfortably with everybody? Yeah, good, okay. Okay, without further ado, Mr Davis, we'll ask you to take us through your summary statement on the knowledge that we haven't really had a chance to read it. It's just arrived this morning.
Sure, thank you, Mr Chair. Yes, the summary statement, I wasn't expecting anyone to have pre-read it because it is essentially my speaking notes for this morning. My name's Stephen Davis, Senior Policy Planner for Hutt City Council, and I'm the sole reporting officer for this topic. I'll do some introductions. I'm assisted by Sean Bellamy, also for the council, although he is not to blame for any of the material you've received. We have in person Marathan Bravaran from WSP covering slope stability evidence, Alistair Osborne for Te Aki Wai covering flood modelling, and online we should have Dr. David Burbidge, Edith Bretherton and Dr. Scott Stevens. I hope that was the plan.
Can we just check that the two witnesses online can hear us? Dr. Burbidge, are you hearing us okay?
Yes, I can hear you. Thank you.
Yes, thank you, and thank you, Ms. Brethren. We got your message that you're hearing us loud and clear also.
Reviewing through the submissions, there are a large number of submission points. I think the issues can be fairly easily divided into, I guess, the modelling and the provisions in the chapter. With regards to the modelling, that's both submission points calling into question so the general assumptions and processes behind the modelling, usually at a district-wide scale, but in some cases for, you know, a whole suburb or something that is specific to a place, and then also people with more site-specific or very small area-specific concerns about the modelling as it applies usually to their own property or the immediate vicinity, and, you know, to what extent a district-wide methodology has been sort of ground-tested or taken account of specific local knowledge. In terms of the content of the chapter, as you say, there's both regional and national direction on this issue, and both of it is quite firmly directive. However, there are a lot of questions about how to give effect to that direction, and particularly how to square the one with the other, as the two have some differences. And then the remaining points tend to be about more nuts and bolts details of rules and definitions. I won't comment on the material that's come in since the 11th of August. I do acknowledge that the rebuttal was slightly late, and particularly the slope stability evidence was late, and I just wanted to note that that's the fault of the council and not having got material to experts when we should have, and not the fault of our experts. I understand you've already discussed with Nathan options about potentially extending the hearing to accommodate submitters who've been disadvantaged by
Just on that, for the benefit of the gallery, there's two submitters that were affected, Mr. Wadham and Mr. Leisure. I think hopefully that's the right pronunciation, and there are plans afoot to deal with those from a process perspective. Hopefully you have more on that later today.
Sure. The only other note for the more recent evidence I will note is I've talked with Dr. Stevens, who does have an updated position in response to the evidence lodged by Lisa Caddis, and he'll be able to speak to that when you get to him. And so, as requested, I'll walk you through the questions you've asked about, both summarise the approach to natural hazards in the operative plan and how the proposed plan is intended to work. The operative...
Just before, the Lisa Caddis evidence, can you just remind us, is that the late submission or is that?
I don't know if it's late technically. She has a site-specific request to remove the coastal inundation
Coastal inundation, yes.
overlay from, I assume, her property.
Okay, thank you. I should mention that the panel has received a request for a late submission to be accepted. Just can't recall the submitter's name. Panel are yet to make a determination on that, and it relates to the slope assessment overlay.
Yes, no, that'll be a separate issue. I don't remember all the submissions off the top of my head, but Lisa Gaddis is submission number 252, which would certainly make it one of the on-time ones. So the operative plan has natural hazard provisions from 3 different eras as it's been changed over the years. The fault rupture dates from the original plan, which became operative in 2003, 2004. Aspects around the Hutt River flooding, so the river topping its banks, dates from Plan Change 6, operative in 2006, and then flooding from rainwater, coastal inundation, tsunami came in Plan Change 56, enabling intensification of residential commercial areas, which is operative in 2023, and two of the panel will be familiar with because you were on that panel. That plan change also updated the mapping for the fault overlay, but not the general policy direction for it. That Plan Change 56 was limited in scope, and so those maps, while they apply to all areas of the district that the council had at the time, they don't apply to all zones. They only apply to some residential zones and the commercial zones, but not industrial or recreation or rural or any others.
Can we just interrupt you at that point? Sure. And I might need some guidance from my colleagues, but in terms of the flooding and coastal hazards in the medium and high density residential zones that were introduced by Plan Change 56, are you able to advise us at what climate change scenario they were based on?
The tsunami modelling is the same as in the PDP. It's based around an assumption of 1 metre of sea level rise, which doesn't correspond to a specific IPCC scenario, but is a joint approach that the modelling was prepared with Wellington and Porirua. Lower Hutt joined that joint modelling late, so it was essentially taking those decisions as made to participate in that. The coastal inundation uses a similar climate change scenario to what's proposed, but I think had different figures around vertical land movement. I think Dr. Stevens can probably give you more details about the exact differences. And then with the pluvial flooding, that both did not cover quite as wide an area, and that the modelling had only been done for 4 of the 6 areas that are included in the PDP, so it didn't cover the Western Hills or Eastern Bays.
Yes.
Essentially the valley floor, Wainui and Stokes Valley was included, and it is based around not exactly a specific IPC scenario, but close to the SSP 3 RCP 4.5 scenario, which is around 1 metre of sea level rise, and more importantly for this modelling, around a 20% increase in rainfall.
Okay. Thank you. Any questions? Yes, let's come to that.
So again, for the ODP for the fault, the general approach is to identify and map the possible fault deformation zone, which does vary as the quality of information, and our certainty around the location of the fault varies along its length. This generally triggers a resource consent requirement for buildings and structures within the relevant area, anticipating that a lot of the time that resource consent will cover identifying where the fault is, and then being okay with that development as long as it's more than 20 metres away. But if it can't be located, or if it is within that, then having a much stricter test around operational and functional needs, and whether there's an overall increase in risk. The PDP generally carries that approach over with some tweaks to details of rules and policy wording. The ODP had an approach to Hutt River flooding, which has been partially removed from the more recent plan change, but what still remains is that it identifies and maps areas within the river corridor itself, and manages earthworks and buildings that might have an impact on flood protection structures. It doesn't generally control risks to buildings and life directly from that development that's being done. It's also that was from a plan change 20 years ago, and the physical stop banks have been reconstructed along a great length of the river since then. And then, as I say, for Plan Change 56, that introduced the pluvial flooding, coastal inundation, and tsunami modelling. The tsunami modelling essentially the same as what's in the PDP, and we discussed before the differences in the pluvial flooding and coastal inundation. It is a broadly similar approach to what's in the PDP, but with a lot of specific tweaks, which is, again, to identify and map areas at risk of the hazards, classifying them as high, medium, and low for the tsunami, high and medium for coastal inundation, and stream corridor, overland flow path, and inundation area for flooding. That approach is carried over in the PDP, except that for flooding, that's now high, medium, and low, and the methodology for dividing it up is different. And Mr. Osborne can speak to that when you get to him. There is quite a complicated policy and rule structure behind that, which reflects the RPS direction in particular, which is quite strong about directing when you must avoid increases in risk, but with some carve-outs to that. But in general, being in a higher flood hazard overlay is associated with higher activity statuses and stricter policy tests. The overlays in the ODP cover buildings, structures, and commercial and residential activities and subdivision. For the PDP, that is extended to also cover earthworks, which are covered in the earthworks chapter, and a much wider range of land use activities that could be affected. However, it doesn't necessarily have the same tests that the ODP had around when those activities change. So I have we're going through slightly not in order of the statement based on your questions. If you are at paragraph 13 on page 4, there's a table there which sort of sets out the differences and how that modelling, the high level change about how that modelling was done and the assumptions behind it, and then how it's been turned into overlays.
Can I just ask you to pause
Sure.
briefly, Mr. Davis? That's one particular matter of detail that I'm interested in hearing from all of your team on today, around the varying assumptions for sea level rise in particular. So if we just look at the rows on page 4 there, where we have flooding, coastal inundation, and tsunami, we have alignment between flooding and coastal inundation based on the PDP for sea level rise, but the tsunami adopts a lower rate. So I guess I'm looking for both an individual comment from the experts about the appropriateness of those assumptions, but also perhaps looking to you for some guidance on why we might adopt a variegated approach as opposed to a consistent approach for different hazards. So that's one point. And I guess that's modulated again by the fact that you were recommending we look at a different assumption for fluvial flooding now and pluvial flooding now. So that's a signal to all the experts today. That's a question that I have about climate change assumptions, why you've chosen the figure that you have, whether that remains appropriate, and also perhaps that higher level point for you, Mr. Davis. Related to that, one further question. For the flooding category, there's a 35% increase in rainfall assumption based on the climate change allowance. But for slope stability, there's no climate change allowance for forecast increases in rainfall intensity. And I think from reading the background material on slope stability, rainfall, and infiltration are relevant factors. So I guess it'd be helpful for the slope stability presentation to just grapple with that, why we're allowing for an increased rainfall allowance for flooding, but not for slope stability.
Sure. Rob will explain this, I think, when you get to him in more detail, but in general, the methodology for identifying the slope assessment overlay is not trying to predict a specific event. It's not trying to put odds on a thing happening. It's identifying areas essentially where a site-specific assessment would be warranted.
Yes.
So the methodology doesn't assume a particular level of rainfall or suggest that area would not be flagged because it would not receive enough rain to have a slip, as it were.
Right.
at a high level for your question, the different hazards all do have slightly different assumptions or rather have different reasons for how they've come to what they've come to. Some of the models are more capable of being rerun with different assumptions than others. The tsunami is particularly computationally intensive to rerun and benefits from scale of being done on a larger scale in cooperation with other councils. So that modelling is some of the older modelling that we have. And again, the concern at the time, which I think is the most important factor in making the decision, is consistency with the other TAs in the region, who in this case the modelling was performed jointly with. The other scenarios have tended to use the IPCC 8.5M scenario, which is what MFE guidance published in 2024 would suggest using, but it is just guidance. The RPS and NPS both have been recently changed and had every opportunity to direct councils to use a specific scenario, and both of them consciously considered the issue and deliberately and specifically decided not to. We've obviously received submissions with people with views on the climate change scenario. I attached the letter the council received from the Minister for Climate Change sharing his views, which are also just his views. So there are many opinions with this. The other councils in the region do not use consistent scenarios themselves, often due to themselves having done the modelling at different times or brought it in different plan changes. That's the main reason for not recommending that the coastal inundation be made consistent with what I recommend for the flooding, because Wellington and particularly Pororua use a higher scenario for coastal inundation than they do for flooding.
Okay.
And I think that cross-council issue of consistency is more important than an inter-hazard issue of consistency.
Okay. I think it'd be helpful to leave that there, hear from the experts, and then perhaps we'll revisit that later.
Yes, I already really kind of covered paragraph 14, I think, earlier. I was going a bit out of order. That's kind of covering the changes from the ODP to the PDP in terms of the modelling. So I'll pick up at 15. One thing to bear in mind through reading through the provisions and submissions, where they refer to the RPS and NPS, is that while our hazards are categorised as high, medium and low, that is not a categorisation of the risk associated with that hazard, which is what the NPS directs using. The RPS gives a choice about categorising either the hazard itself or the risk. And the categorisation is essentially a way of splitting out the event based on either its probability, severity or distance into the future. And for some of the hazards, the whole hazard overlay is ranked as just one of high, medium and low. And for the ones where it's broken out, each one uses a different factor. Flooding is based on the depth and velocity of the floodwaters and whether it's an identified stream corridor. For the tsunami, it's based on the return frequency of the tsunami, so whether it's a 1 in 100, 1 in 500 or 1 in 1,000 year tsunami. And for coastal inundation, the difference between high and medium is whether or not you're considering the present day event or the event using the climate change assumption. So when a resource consent is triggered and the NPS would have to be considered, the risk would have to be considered at the consenting stage. And that's kind of inherent with the structure of the plan anyway. You can't really assess the risk until you know what the actual proposal is. So the provisions that sit under this are almost entirely triggered through the spatially defined overlays. You can't theoretically completely ignore the chapter if you're not within the overlay, but it will have essentially no bearing on you. The risks for all the hazards except liquefaction and fault is based on the high, medium, low categorisation, avoids new and expanded buildings and sensitive activities in the high hazard area unless there's an operational functional need or various regional significance, which is intended to implement the tests in the RPS for that. Also testing that the risk overall is not increased, or that for some reason the development is less sensitive to the danger, either by being a activity that's not particularly sensitive to hazards or has low occupancy or low replacement value, and so the consequences of that thing being destroyed in the hazard event are low. In the medium and low areas, the approach is to minimise the risk to new development, including where possible through mitigation measures, and in some cases evacuation requirements. One of the main mitigation measures for flooding is the requirement for minimum floor levels to ensure that habitable spaces are above the floodwaters. And then finally, to encourage retention and enhancement of natural features and processes and other hazard mitigation works.
Mr. Davis, can you just pause there? Those risk directions, also policy directions based on risk, are they a reflection of the direction in the RPS prior to PC1? It's just that you said that when the plan was being produced, and I don't think you had any direct involvement in this chapter, that the council was cognizant of the decisions version of PC1.
Yes, I mean both. The PDP has evolved from its draft into its notified form, and then with my recommendations of the 42A, bearing in mind what's happened in other councils in the region and what's happened with the RPS, it is sort of a fairly similar approach across councils in the region. There's sort of a summary of that in the appendix, I think B6 to the 42A report.
Yes.
The RPS itself changed in the hearings and obviously was appealed, including by Hutt City Council. And so the RPS provisions have also evolved since the notification of the
I understand
PDP.
that, but the question I have is the words to avoid new and expanded buildings and sensitive activities in high hazard, to minimise risk in medium and low hazards, are those propositions ones that are directed by the RPS unchanged by PC1, or do they reflect some nuance as a result of PC1?
At a high level, it certainly does. That was part of the direction of the RPS change 1 as notified, and this plan was notified after that change. The RPS was notified. There's certainly a lot of nuance that's changed over the course of the hearing and the appeal
Okay.
to that RPS direction.
Okay, so it's a hybrid in a sense, the approach.
I wouldn't necessarily call it a hybrid. I'd say it's a high level with then distinctions made further down. The RPS is framed as some fairly blunt high level directions with exceptions to it.
Okay, thank you.
For liquefaction, there's a similar approach, but it only applies to a fairly narrow category of activities, reflecting that liquefaction is primarily a risk to buildings and not to life. And so that's generally targeted activities that it's critically important continue to function in the immediate aftermath of an earthquake, or that people are likely to go towards in a major earthquake despite being warned not to, such as childcare centres. For the fault hazard, the approach is quite similar to the ODP, but also includes, like I say, avoiding new and expanded buildings and sensitive activities based on that operational functional need and risk tests. Finally, the slope assessment overlay is quite different to the others, and it's categorised in the PD and the plan is notified as having a medium severity. I recommend in the 42A removing it from that table and not describing it in high, medium and low terms, because it's not predicting a specific event. It is essentially intended as a screening tool for whether or not it is worth requiring a resource consent for a site-specific geotechnical assessment, and is triggered only from earthworks and subdivision rules. There's no general land use rule behind it, which means that only sort of the policies behind it and the identification of the overlay within the stream, all of the actual rules that sit under it are in Hearing Stream 7, where the earthworks and subdivision topics are handled. There are obviously rules to implement the policy approach for the other 5 hazards. This includes categorising activities into their sensitivity to hazards in 3 groups: least sensitive, potentially sensitive, and most sensitive. I can only really give a high-level summary of the rules because they are quite complex, and there's only so many sort of overall themes in that complexity. But in general, the higher hazard overlays and more sensitive activities are associated with more restrictive activity statuses and tougher policy tests. All of the hazards, like I say, also have provisions in the subdivision and earthworks chapters, except for liquefaction, which does not have earthworks provisions. You asked specifically about vegetation removal in the questions you sent me over the weekend. So just to clarify, there are no provisions that control vegetation removal for natural hazard reasons, but where you do trigger a consent for vegetation removal for some other reason, or from something that's not vegetation removal, it would sometimes be in scope to consider that effect, particularly on slope stability, which is called out in some matters of discretion. So hopefully that's given you something to start with. And yeah, happy to go over to your questions. Obviously we have our experts here as well, and some of them have limits in their availability, so I'd encourage you to ask.
Thank you, Mr. Davis. That's been useful, particularly for me, in terms of understanding the provisions as they exist in the ODP and the new provisions proposed in the PDP. Just one question before I go to my panel. With the slope assessment overlay, is that a new concept that didn't exist in the ODP, or did it exist in a different form in the ODP?
The ODP did control earthworks with an eye to slope stability, but in a much more crude way. Some zones simply had no permitted level of earthworks, and so slope stability would be considered essentially for any earthworks on the site by triggering a consent.
Yes, but there was no overlay per se in the ODP.
So
was there a sort of a slope factor, or?
Well, it was triggered through the zone, which was the Hill Residential Activity Area.
Okay.
And so to the degree to which the Hill Residential Activity Area lines up with areas that have slope risks, which is, I guess there's some correlation there, but it's not, it's not based on any modelling or any scientific assessment of the risk or anything. And then you would consider, for other sites, geotechnical risks at subdivision stage.
Okay, thank you. Just see if I've got, yes.
Just to follow up to that, and the earlier question I was asking about the climate change assumptions for rainfall that are adopted in flooding and not in the slope stability work. I guess another way of asking that question about the slope stability overlay would be, would we anticipate a need to modify the extent of the slope stability overlay if we did make a greater allowance for increased rainfall? Or would the spatial extent of the overlay remain static irrespective?
I could answer that, but I think Brad will probably be able to give you a better answer given he's right.
Yeah, I'm happy for that to be.
Yeah.
Thank you.
Thank you, Mr. Davis. It appears that that summary's been met with good reception from the panel and no further questions. We may now move to Mr. Quinn, I think. Welcome.
Thank you, Commissioners.
Thank you, Mr. Quinn. Two things. Thank you for attending to this matter at short notice last week. Your 14th of August memorandum was very useful, and I noticed you reattached your 8th some May advice too, which was useful for us to familiarise ourselves with again. You're dealing with a couple of matters there. Firstly, a scope issue on stringency of submissions, and then secondly, the relationship between the RPS and the MPS in light of the recent consent order. Did you want to begin with a summary position, or do you want to go straight to questions?
Certainly, what I thought I might do, because obviously I've touched on the two topics that you outlined this morning.
Yes.
And from a legal, and I've endeavoured to cover it just from a legal perspective, because both topics are a combination of legal, planning and technical. And I take the point that it's not just legal in isolation. So I've endeavoured to limit myself to the legal issues. From a legal perspective of the two topics, one's a bit easier than the other. So I thought I'd start with the easier one, and that's the order I've put it in the advice. So maybe if I run through just a summary of my position on each question, then open that topic up for any questions, if that's of assistance to you.
That's the perfect approach.
Okay. So the first topic addressed is the proposal by Mr. Davis to rerun the model with different assumptions on climate change. And from a legal perspective, and I think it's reflected in the minute from the panel, there is a distinction between whether you should do that and whether you can do that. And the should component is a matter which is a technical question and a question for the panel's discretion. And so I haven't focused my legal advice on that, because that's really a matter for your ultimate determination based on the evidence of others. So my focus has been more on the legal question of whether you can do that. Now, what we're talking about here is obviously the recommendation from Mr. Davis to make some changes, and then there's the practical issue in terms of when that should be done, given the time and cost of completing the models again. I've relied, in terms of just providing some legal guidance, on the outline and the rebuttal evidence of Mr. Davis in terms of the particular submissions that he relies on to say that it can be completed as recommended to enable that to occur. And having gone through and considered those submissions, in particular, I'm referring here to paragraph 4.8 of the rebuttal evidence, which sets out those various submissions. I think there was about 8 submissions identified. I, from a legal perspective, agree with that analysis, and to try and provide some assistance or comfort to the panel in that regard, I endeavoured to address some of the case law that can be relied upon in that regard, and that's particularly covered in paragraphs 6, A and B of my written advice. And I think that provides some case law guidance to justify that conclusion and support that recommendation of Mr. Davis, that his recommendation to you can be done. In reaching that analysis, there's obviously a heavy focus on what was notified in the proposed plan. And that becomes vital in terms of the case law from a legal perspective. And the theory obviously is that at the time of notification, any owner or someone with an interest in property could ascertain the constraint over their land and then could choose to submit. Whether they do submit or not, in some respects not relevant, or whether they in fact availed themselves of the opportunity to actually review the proposed plan, again, is in some respects not relevant. The key point is that they had the opportunity at that date to review what the proposal was and to ascertain what impact it had on their property. So against that background of that being the key date, what we want to do now is avoid any new constraints post-notification of that proposed plan that would catch someone unaware. And really that is the thrust of the key test in the case law. Would someone be caught unaware? And that's why I provided in particular that quote from Motor Machinists in Palmerston North City from paragraph 77, which really, in a more detailed way, says that very point. We don't want a scenario where someone comes along with a submission, that submission's accepted, it affects properties across the board, and someone is caught completely unaware that all of a sudden their property is constrained in a way that wasn't in the notified plan. And that, looking at it through that lens becomes, in some respects, quite slightly, it's almost the easier piece of the puzzle, because that's when you look to impose something which is more constraining on a property, and therefore you're going to have potentially a series of people that are aggrieved by that. Here, in terms of the recommendation, the primary recommendation from Mr. Davis is almost going the other way. Would there be a reduction in the degree of constraints over properties? So someone who might have looked at a notified plan and thought, oh no, that's unfortunate, my property is constrained, perhaps now under remodelling, it wouldn't be constrained, or wouldn't be constrained to the same degree. And so that's why I kind of address that and say, and I look at the other example I came up with, the Oyster Bay Developments case, where there could, in that case, there was a reduction in the size of the zoning as a result of a submission. And so that's another way really of saying it reduces or removes constraints over potentially someone's land post-notification. And the conclusion that I've reached is that provided there is the scope that can be relied on through submissions, going back to the submissions Mr. Davis identified at paragraph 4.8 of his rebuttal, then such an outcome is a possibility. In other words, you can do that, and whether you should do that is a matter of considering the technical evidence and exercising your discretion. So that, in summary, Commissioners, is my advice in relation just to that first topic, and I'm happy to take any questions or discussions on that.
Yeah, yes, we'll take some questions. Just an observation, late last year I had half a day procedural hearing at Palmerston North City Council, which involved a very in-depth forensic focus on the motor machinist's case by Nicholas Jesson and Dr. Claire Kerman. Mm-hmm. That decision's since been issued, but Dr. Kerman drew my attention to a case, and I can't remember offhand, the North Shore case, which she felt challenged the motor machinist's case in some way. Sorry to put you on the spot because I can't recall what that particular case was, but do you have any knowledge of any more recent challenges to the motor machinist case, which was over 10 years ago now?
It is, yes. And it's been obviously the subject of a lot of judicial discussion, because it still seemed to be the guiding case in terms of the almost the two stages of consideration.
Yes.
My broad understanding is, although it's been referenced and restated, I'm not aware that it's been overturned. And in fact, to be frank, if it was overturned, there would have been much made of that, much written about it.
Sure.
So I don't think it's been overturned. I think it's possibly been restated or rephrased in cases.
Yes.
But I'm certainly not aware that it's not good law anymore.
Yes, and the two stages being on the plan change and then the fairness.
That's
issue.
correct. That's
Yes.
right.
Okay. I have a more generic question about the direction of travel where the change that might result from a remodelling might catch submitters unaware who were in support of the provisions as notified. Now, I don't know whether there were any submitters, perhaps Greater Wellington, but if any submitters supported the provisions as notified, but now there's a procedure to perhaps rerun the model and with less conservative assumptions on climate change, what would you say to that in terms of fairness?
I think it's a very good point, and I was contemplating this when I was writing it, because almost there's an implied assumption that homeowners don't like constraints, and if you remove a constraint over their property, they're happy.
Yes.
And that's almost implied in an assumption here, but I think you're right. It's actually the case where there are potentially three scenarios. First of all, there are submitters and even potentially some owners who like to have a recognition or a constraint over their property.
Yes.
Perhaps more unlikely because most people don't like it, but there's a possibility that some do. Or you've raised the possibility that it might not be a situation of a homeowner, but it might be a regulatory body such as the Regional Council. Then you have the ones in the middle which are simply neutral. They might have even read the notified plan. They say, well, if that's what the experts in the modelling say, so be it, and we're not going to submit on it, we're not going to challenge it, it is what it is, very much in the neutral category. And then you have those in the category that don't like any constraints and say, the more constraints, then the more difficult it is for me to develop my land, and as is often the case, of course, because it gets raised many, many times, people say any district plan constraint carries an impact on valuation.
Yes.
And although obviously that's always something that you can't take into account directly, it's a motivation behind many submissions in terms of impacting valuation or saleability of properties. I think it's probably a reasonable assumption to make that the majority of people, as it relates to someone being in a land ownership capacity or having an interest in property, would prefer to avoid a constraint or an overlay or a limitation over their land rather than have one there. But without a doubt, there are regulatory bodies that might simply say, so be it needs to be there for the purpose of broader protection of those property owners or the public generally. But I think here I'm certainly looking at it from the perspective, and acknowledge I'm looking at it from the perspective, and lots of the case was looking at it from the perspective of the impact on a landowner.
Yes.
And what it would be perceived by a landowner who might be notified, look at the plan and say, what impact does this proposed plan have on my land?
Yes.
Whereas I think in terms of those regulatory bodies, they're not looking at it through that lens. They're looking at a proposed plan in terms of whether or not it implements broader obligations and considerations and their potentially higher order documents. It links back to our second question.
Yes.
So in some respects, when they're reviewing the proposed plan, they're reviewing it through a different lens, and they will be aware of it and more likely following through and participating in these planning processes than individual property owners are likely to.
Yes. Thank you for that. You certainly squared away the third scenario of submitters who are opposed and wanted less regulation. You probably also covered off the second scenario of submitters such as regulatory bodies who have submitted either in support or neutral, and they have an opportunity to be involved in the proceedings. Excuse me. I'm still uncertain as to whether the panel should be having some regard to people who did not submit because they were happy with the notified approach to hazard management, particularly flooding. Is it possible that they could be caught unaware of this procedure in the same way that you said in terms of submitters who perhaps, well, in terms of how you categorised submitters who might be unaware? Is that scenario a realistic one, or is it more of a straw man scenario?
I don't think I can say legally it's not possible. It is possible, but I think it's less likely.
Yes.
Less likely from the perspective, from two perspectives. One, I think the vast majority of people with an interest in property would be in a situation where they would prefer to have less constraints rather than more constraints over their property. Secondly, those that are regulatory bodies, and although I say that kind of generically, in reality, we're talking about a small number. I mean, it's predominantly the Regional Council, and the Regional Council's obviously a submitter here and is involved in this process. But they are looking at it more from the generic perspective, and in some respects, even through the minute, that you issued, which provides an opportunity for submitters to participate. In some respects, that covers that off. So the residual risk arising on that topic is extremely low.
Okay. The situation that the panel in the Palmerston North case found themselves in was an intensification plan change. The council had identified an area of medium density, and they had defined that spatially and zoned it medium density zone. The advice that the panel received was that the submitter, in that case, Kaingaroa, which had sought to extend that area, was not on the plan change, and even if it was, would create some fairness issues for people who hadn't submitted because they were outside the intensification and were happy with the general run-of-the-mill residential zoning. I just wondered whether there's any similarities between that scenario in reverse with the hazard scenario that I outlined in terms of scenario 1, where people haven't submitted on the hazard overlay spatial extent because they're happy with it, and now they're finding there's a possibility that it's going to be reduced in extent and they don't have any recourse to have input. I understand what you're saying, that it's more in the unlikely category, but is it something that we should have regard to?
I think you should have regard to it by turning your mind to it, and then you have to assess the extent or the degree of risk of that. Okay. And that's where I get into the point of that risk being low. I take the point that you're raising, Commissioner, in terms of comparison to the housing intensification process. The one thing I will note about that is obviously that was forced on councils because of the legislative change, and most councils, including even dealing with appeals against Wellington City Council's plan, they were very protective and clear from a council perspective that by implementing those changes, they hadn't changed the underlying zonings. And they were quite resistant to any submissions that sought to expand or reduce the underlying zonings, because they said that's not within the scope of our plan change. Our plan change is limited solely to amending our plan as required by the legislation.
Yes.
So I think I take your point, it's useful because it's recent by way of a comparison, but the context of those plan changes around the country was quite different. Yes. Whereas, of course, this, because it's a proposed plan as a whole, it includes the zoning as well as the rules, and so it's a slightly different starting point.
Thank you, that's useful. I'll leave it at there and just invite my...
Thank you. Just a couple of follow-up questions, really. So I guess generally is your position that any reduction in constraint is automatically within scope? Or, and even if submitters didn't expressly ask for that outcome?
Yes, so the submissions relied upon a series of submissions which are more general and have much wider scope, and looking to, I suppose, address or challenge the approach to the way in which the overlay has been generated as a whole. And in some respects, from a scope perspective, that type of submission or that collection of submission gives much more opportunity or much more comfort to a panel that gives them the power to do what they need to do. If those broader submissions didn't exist and there were just one or two submissions which were property-specific submissions, then in some respects the recommendation from Mr. Davis wouldn't be able to be implemented because it wouldn't be within scope. It needs those broader submissions to give the jurisdiction to enable that to occur.
So the submissions that Mr. Davis has identified, so we've got two camps, haven't we, of submissions? We've got the general and then we need the specific.
Yes, and so most important to this
jurisdiction.
question is the general submissions.
Yeah. So are the specific, are they enough to provide that jurisdiction for adopting a different climate change scenario rather than simply critiquing modelling inputs?
I think the short answer is yes. I mean, I look at it from the perspective of saying, if this was being argued from a legal perspective before the court in terms of what the powers of this panel were, or indeed if it was appealed, what the powers of the court were, I've no doubt that they would say, we have the powers. And that's, I don't want to get too cynical, but most of the time I appear in front of the, particularly the Environment Court, when you tell them they don't have jurisdiction, they generally say, thanks, but no thanks. And so what they look for is this type of scenario where we say, is there a general submission which broadly covers or challenges that particular topic? And to the extent that that topic is challenged, then that gives enough for the type of changes being contemplated to be enabled, obviously subject to the technical assessment and your consideration that you think it should occur.
Sorry, just one more, if you don't mind. Could the same be said in regard to the modelling scenario? In order to rely on submissions, so should those submissions seeking a reduction be more specific?
I'm not, sorry, I don't quite follow the question.
So
sorry, Commissioner.
following on from, we've got to have a general and a more, the general submission to rely on. So within the modelling scenario, are those general submissions regarding the modelling scenario, are they enough to provide that jurisdiction as well?
Yes.
Yeah. Okay. Thank you.
Just on that, and it might be useful if Mr. Davis could provide some further information in his right of reply, and particularly in relation to the last sentence of paragraph 4.8 of your rebuttal, where you say some of these submissions explicitly reference the choice of climate scenario or recency of the LiDAR data for a reason for removing the layers in their entirety. But could you perhaps expand on that for each of those submitters, Mr. Davis, so that we can see where specifically the questions that Commissioner Burge had raised land?
Yep.
Yes.
Thank you, Mr. Quinn. I just wanted to perhaps tie together the first answer you gave to Commissioner Burge with maybe the last answer you gave to Commissioner McMahon, and the degree to which those broad submissions might also speak to the risk assessment that you advised the panel should undertake in relation to that first scenario that Commissioner McMahon highlighted, where a party might have been happy with the notified provisions and wouldn't have the ability to participate on a revised smaller set. Is that ameliorated to some degree by their ability to cross-submit on those original broad submissions?
Yeah, so just to clarify, Commissioner, you're saying a submitter who chooses to participate then almost as part of the tent and gets to see the submissions that others make and then gets to comment on those or even adapt their submission accordingly by taking into account the general submissions.
Yes, and also all parties have the ability to cross-submit on original submissions.
Yes.
And so if original submissions sought the broad relief that we are relying on potentially here, any party would have the ability to cross-submit on that.
Exactly right. And I think in that respect, and there's much more limited risk as it relates to parties who are already submitters, because having been submitters before, they are notified, they're part of the process, they are in a much better position to inform themselves as to what's going on, and they can further submit. The focus pretty much of the case law is generally not so much on those parties, it's those who completely are outside of the process in the first place because they didn't even choose to submit right from on the start, and therefore they're left out in the cold. Hence why I suppose the reference in the case law to those being surprised by a change that affects their property that they had no knowledge of or no inkling from when reviewing the notified plan.
Yes.
So I think, without a doubt, you can have a level of comfort in terms of those who are submitters, in terms of their ability to cross-submit, both in terms of what it might, jumping on the bandwagon, if you like, in terms of the way in which their submission is supported by others, or the other way around, that their submission might be contravened by others. They certainly have an ability to participate both ways.
Thank you, that's very helpful. I just had one question, if you like, of fine detail, and it's related to paragraph 7 of your most recent advice. And so we talk about the second test of motor machinists. And you say in the middle of the paragraph, on the basis that the modelling reduces the area of overlay and therefore the property is affected, this would not undermine public participation based on the notified PDP. I think the question of detail I have is, would you advise the panel to take or to give directions if we instruct that additional modelling to have some pretty close I's being dotted and T's being crossed to ensure that we don't have any increases?
Absolutely, and that's why I couldn't comment in too much detail, because of course it comes down to the directions that you give in terms of the scope of the modelling and the criteria to be applied. And I think as I read the recommendations from Mr. Davis, he was saying because there are so many factors involved and there's a cost and time delay, we need to lock that down first before giving that direction. Yes. But I think in terms of the direction that you may choose to give if you go down this track on scope, that could be one of the criteria that you look to apply, because it's consistent with the legal analysis. So it might be just another matter of overlay or final cross-check on the outcome of the modelling, so that you're not caught in a situation assuming it will be a reduction, and then for some reason in some areas it's not a reduction, and you don't want to be caught out by that.
Thank you, that's helpful.
And Mr. Quinn, this was supposed to be the straightforward matter.
Yes.
Just before we get on to the, we're breaking at 11 for morning tea, so just before we get on to the second, more complex matter, Mr. Davis, just in your right of reply, could you advise the panel as to what notice was given at the summary of submission stage, inviting further submissions? Was that through a general rates advice, or was it through public notices in the paper, or was it just limited to those submitters that were on the record? Secondly, could you also advise in your right of reply whether there were any submitters who supported the notified provisions particularly on hazards and sought no change?
Yes, I can do that. More detail on the right of reply, but the short answer is yes, there were submitters who supported the flood hazard overlays, either for specific sites or in general. The Regional Council submission also technically or theoretically sought that the maps be completely replaced with a new set of maps that they sent in, but in practice this was to add certain areas to the maps that were already in the plan. So I guess de facto that's a submission point in support of the notified maps.
Yes, okay. We'll have an opportunity to quiz Ms. Wheatley on that, I think on Thursday morning. Just a simple table would suffice on that. Thank you. Mr. Quinn, the second more meaty topic.
Thank you. So obviously this topic was generated by the RPS more recent consent order of the Environment Court, but it brings into play and it cuts back into some of the issues we obviously considered in May in relation to higher order documents. What I've endeavoured to reflect, certainly right from the start of my paragraph 9, is some degree of sympathy for the position of the panel in this scenario, because it's messy, and it's messy legally. Now, it's not an unusual topic that in terms of assessing in a district plan context that you have to consider higher order documents, and that's a moving feast. I mean, that in itself is not unusual. But what creates the mess here is the number of documents, the timing, and to make it worse, the statutory plan stop. So if we go through kind of each of those first, the statutory plan stop obviously is without precedent. It means that until at least the end of next year, the council can't notify any plan changes. And you say, well, that's fine, that's just what the law provides and that's correct. But the trouble here is that the only way to perhaps properly implement a high order document is to go through a Schedule 1 plan change process. And the law is telling the council they can't, at least until the end of next year. The timing of that was intended, I think, by government to reflect when the new world of RMA amendments are to be in place, or at least there be more certainty around that. So that's a critical issue because, of course, quite naturally, from a submitter perspective who are looking to make changes, they're saying, here's our last chance. We're going to put pressure on you, the panel, to make changes because the council can't do it themselves, at least until the end of next year, and then who knows what's the case at the end of next year because what the legislative changes might be. Likewise, irrespective of pressure from submitters, again, there might be some desire from a panel perspective to make changes for the similar reasons. There's no other way for it to be dealt with through a normal process. So that's one element of perhaps the messy scenario. The second element here is the timing of national documents. If we're honest about it, we went through decades under the RMA where the government issued next to no national documents, and then all of a sudden it got a head of steam and started to issue them all over the place. And we're talking about a series of national documents that have come in after the notification of this plan change. So all of a sudden there's more national direction, there's more recent national direction, and that then becomes of relevance to this topic. Then the regional council is in some respects in a slightly similar position because it's got to implement the national direction and it's got to follow through the same Schedule 1 processes. And at the time it notified its RPS, the relevant national document here in terms of natural hazards was not introduced. So its own RPS did not implement the national documents. The way in which it endeavoured to do that was to try and address that through Change 1, and then that was then subject to appeals. But interesting, at the time of Change 1 being notified, the national documents weren't in place either. So in some respects, the tweaks that were made to Change 1 through the appeal process and through the consent order was an attempt to do a little bit of catch up as well. When you add all of that up, you think, what a dog's breakfast, really, in some respects. And that creates the difficulty that you're facing here. So I recognise in my advice there's kind of that temptation to try and rewrite or update or future-proof the PDP to best align with the higher order documents. And I can understand that as a broader concept or desire and promoted by some submitters as well. I mean, naturally, because they will take the opportunity. What I've tried to do against that is not so much a matter of saying you can't, but I've tried to give a degree of guidance to say, do so with a degree of caution. And that's all I'm really promoting at this stage, because of course, it's not like I have in front of me what the proposed changes are in any detail, and to be able to assess those and say whether that, what's the risk in terms of a court saying legally that's in or out. So it's more about at this stage a degree of guidance and what I'm saying is a cautious degree of guidance because of the similar issues to what we discussed before, that the changes that might be made to the proposed plan were not notified through the proposed plan, and therefore there's nothing that's been presented to potential submitters in terms of the fulsome extent of changes. So I say despite the potential frustration, what I promote legally is that the safer approach is only a minimal degree of changes to align to ensure there's no need to get close to a situation where it might need to be re-notified. Because the moment we get to a point where it might need to be re-notified, we get into the scenario under the plan stop, you can't re-notify. So the moment you start to get to you're making changes which are going too far and getting close to a re-notification because submitters haven't had a chance to actually express views on those things, then I think at that point you need to say, is this going too far? Do we need to exercise some caution? Now, I note on the substantive issue, you have advice from Mr. Davis in his rebuttal evidence to say there's actually already a reasonable degree of alignment between the PDP and the RPS as reflected through the changes on change one anyway. So that's the substantive assessment that you've got to go through and engage with that and work out, whether you accept that evidence and what is the degree of the nature of change. All I'm saying is from a legal perspective, the greater risk comes with the greater degree of change. And because of the messy scenario that I've painted in the advice, or just now this morning, I've reflected on the advice. I'm happy to review again any proposed changes the panel's considering in terms of assessing scope and risk, because we're talking about it now in a theoretical sense or a general sense, not in a specific sense with any changes in front of me. And that's why I think I've referenced a little bit, just right at the end, in broad terms, it would be somewhat safer to consider potential amendments to policy or objective wording for the purpose of satisfying yourself as to alignment with higher order documents. I think the moment you start to get into making too much change or proposing too much change to rules or the overlay methods or models, then the greater degree of risk arises at that point in terms of making those substantive changes which would get close to a scenario where objectively, if it was challenged in court, they'd say that's the type of change that should have been re-notified. So I don't put that up as a legal test to say you can tweak and change policies and objectives as much as you like, but the moment you touch rules or overlays, then you're in a difficult position. But I think in terms of broad guidance, that's the type of consideration that you might consider when you're looking at this issue of how far can we go in this current unfortunate messy scenario we're faced and still be on safe ground that we're not overstepping the mark.
Okay. Thank you, Mr. Quinn. There's a lot there to digest. I'm going to have a stab at it.
Yes.
And then I'll ask my colleagues to come in. You used the can we and should we scenario when you were discussing the first issue, and it's probably equally applicable here.
Yes.
I think on the can we, I think it's probably saying probably. Should we be careful?
That's right. So I think in some respects it's a useful starting point in terms of the analysis from Mr. Davis to say there's already a strong degree of reliance or alignment. And I think you need to review that and assess that and work out whether you accept that. If you accept that, in some respects, the issue drops away a little bit, or at the very least, that provides a starting point to assess that position versus what you might be asked to be make changes that submitters might ask you to make.
That is a good starting point, albeit that Mr. Brown possibly has a slightly different opinion to Mr. Davis on the degree of alignment, and we need to understand that.
That's right.
We're some way from resolving that.
Yes.
But yes, that is a useful starting point, and we will test Mr. Davis and Mr. Brown on that. Just a couple of questions before I put a proposition to you. Can it be said that the RPS now implements the MPS NH as a result of the consent order?
I think the answer to that is partially.
Partially.
And the reason I say that is because of the timing issues where the notification of the RPS and change one occurred before the MPS natural hazards was introduced. It was addressed in a way through appeals and through the consent order in a way where they endeavoured to align, but it wasn't a situation where you have the ideal trickle-down scenario. You have the national document first, then the RPS, and then the submissions on that. It was addressed through the nature of the process. So I think there's partial implementation, but it would be difficult to say there's full implementation when it went through a slightly different order.
Yes, okay. No, that, I've recorded that. Thank you for that. Secondly, you say you referenced the plan stop and that councils need to implement, give effect to MPSs through a Schedule 1 process, but prevented from doing so to at least the end of 2027. Does that take into account that they could possibly seek an exemption from the minister to institute a Schedule 1 process to do exactly that?
Yes, it's interesting because I've, in other contexts, have been advising councils as to whether they should initiate some, will make an exemption application, and actually some have. You know, I mean, obviously this council has, because that's the reason you're sitting, but there are other councils who have sought and obtained exemptions for specific type of plan changes, topic-specific plan changes, and so it is still possible. Often the minister's consideration of whether that will be granted is actually in relation to what topic.
Yes.
If it's a topic I think that the minister considers will be substantially potentially amended or reviewed through the amended legislation, the minister is much less likely to grant an exemption. But if it's a topic which perhaps will remain potentially unchanged or will certainly be one of the relevant considerations, and there is a stated need, then exemptions can be granted.
Okay.
So I think we have to acknowledge the potential for an exemption to be sought. I mean, and when I look at those topics, I mean, you will be aware, obviously, that this council, in terms of this proposed plan process, didn't seek an exemption for the whole proposed plan. There were topics covered by the proposed plan that exemptions weren't sought for or granted. And some of the reasons for that, because those were the type of topics where the minister thinks will be subject to statutory amendments. The other thing I obviously should note as well is that the national policy statement for natural hazards here is slightly unusual in its wording because, of course, it was introduced after the plan stopped. And so Ministry for the Environment officials were aware that at that time councils could not go through a normal Schedule 1 process. So what it does is it says, it doesn't give a time frame.
No.
It basically says, it will occur in due course. It's in some respects an acknowledgement that implementation of that national document may take many years because they couldn't require a particular time frame when the legislation says that they
Isn't the
can't.
term as soon as practical, or is
That's right, and
Yes.
so as soon as practical does clearly have implications in terms of when it can occur on a.
There were a number of councils that were, district councils in particular, Timaru, Waimakariri, Far North, that were in a position of nearly issuing their decisions on their plans when the national hazard, when those scree of MPSs came out in January.
Yes.
And most of them played the as soon as practicable card and said that it wasn't practicable to revisit their decisions.
Yes.
Some of them, like Far North, were on a second extension already, or were in the position that they'd have to go back to the minister and say, because of these MPSs, we can't meet our second extension.
Yes.
I just wonder in this case.
Can I just go back, Commissioner, just on the exemption thing? The one thing, of course, I didn't complete in my answer is that there are some automatic exemptions.
Yes.
And if I look at, and I'll just pull it up in front of me, which is, I think, around section 80.
Hazards.
80U. Yeah. And there is an exemption that relates to natural hazards. So depending on the scope of a potential future plan change, it may well be that we don't necessarily have to go through the
Yeah.
ministerial exemption. So perhaps that needs to be noted as well. So under
Yes.
ADU deals with automatic exemptions.
Without going to the minister.
Yes.
Okay,
Yep. So,
that's-
again, my answer is subject to that as well, in terms of that has an impact on process.
Okay. Final question, and it's really the proposition in a sense, is to what extent is this a unique situation that Hutt City find themselves in that possibly the first case where the courts have made a ruling on the MPS natural hazards, the RPS, in your views, is at least partially aligned with that, and we have to give effect to higher documents, both the MPS and the RPS. Isn't this an opportunity to try and do that, notwithstanding the exception process or the exception to the exemption process? Isn't that an opportunity and for this panel to try and grapple with that?
Yes, there is an opportunity, but in terms of how you avail yourselves of that opportunity, what I'm saying is, if you go too far, then you are exposing yourself / the council to a challenge from someone who will say, rather than utilise this opportunity to, and I'm taking a more extreme position, completely rewrite the provisions, why doesn't the council follow using an automatic exemption, notify a plan change and do it on a more wholesome way so
Yes.
that everyone has a chance to have their say?
Yes.
Because if you, for example, avail yourself of the opportunity to do more substantial rewrites of the provisions, you are only engaging in the submitters who chose to be part of this proposed plan
Yep.
process. You have no opportunity to engage in other people who are affected.
Yes, and we went to a
and
motor
that's the risk.
machinist scenario there in terms of fairness.
That's right.
Yes.
Yeah, and that's why I'm saying there is an opportunity where the line's drawn is a matter for your discretion. The further you go in terms of availing yourself, the greater the risk. I think there's less risk in relation to perhaps some policy and objective tweaks,
Yes.
but the moment you start to deal with the rules or the overlays, greater risk,
Yeah.
because that's when the people who might put up their hand to say I wasn't part of that process
Sure.
could come into play.
And I promise this is my final question, and that pick and mix approach, if I can call it that, about focusing on policy, isn't that also have an inherent danger also in that you might tweak the policy's objectives, give us slightly different policy direction, but the rules don't implement that direction? I mean, that's a risk also, surely.
That is a risk, and without being too direct in terms of my advice, I made the point that when particular submitters look to make tweaks or proposed tweaks to a panel, they're obviously looking at it, I mean, if it's recommended by a lawyer or a planner, they're looking at it through their client's eyes, and they're looking at it through what they'd like to see. The intention behind, obviously, a Schedule 1 process is the council's meant to look at the whole document in totality, its whole plan in totality, and do a fulsome review on an objective basis, and consider not only the impact in relation to the natural hazards part of the plan, but also look at what other parts of the plan might be affected and cross-referencing and alignment. In other words, it's looking at it from a complete planning policy perspective afresh.
Yes.
And of course, the pick and mix approach, which perhaps might be promoted by particular submitters, are not looking at it through that lens, they're looking at it through a different
And
lens.
we've heard from Mr Davis that earthworks and subdivision, for example, are subject to different chapters and a different hearing stream.
That's
So,
right.
yeah, and those provisions will partially implement some of the natural hazards objectives and policies.
Yes, yes.
Okay, I'll leave it at there, but I'll invite my...
Mr. Quinn, Commissioner McMahon's traversed a few of the issues that I wanted to get into, so that's been really helpful to get your responses on those. I have two additional questions I wanted to ask you about. One of them is at the end of your paragraph 14, and this is something that I think you and I spoke about briefly in hearing one, and about if the panel was going to be going through this exercise, one potential future outcome might be that the panel ultimately decides that we don't have scope to make changes that we think would be necessary to fully implement a strategic document. And therefore, in a practical sense, that's going to mean greater reliance on those higher order documents at the consent stage in the future. I'm curious to know, and it's I think partly a legal question and partly a planning question, so I'll be interested to know Mr. Davis's thoughts on this too, but where the panel identifies a clear disconnect, is it helpful to future decision makers and users of the plan if we do so in a way that is clearly signposted in the plan, so that there's a known resource management gap between the district plan and those high order documents, and people can approach their resource consent applications and assessment of policy in a structured way, and potentially with greater consistency than if we were to remain silent on it?
Short answer is, I think, yes, to that question. The messy scenario that I talked about before, you could reflect that in your written decision, but the reality is that a resource consent applicant in a year's time won't possibly be reading your written decision. They'll be simply reading the plan. So in view of that scenario where you feel like you're in a position where you can't fully implement the national documents through the RPS and you are constrained, you may want to reflect the rationale or the reasons for that principle either in a part of an overview explanation of the chapter or through some type of advice note equivalent in the document itself to provide a degree of assistance and if you like, warning to future consent applicants as to the type of topics that their resource consent application will need to engage with. And I say that generically because, of course, it depends what they're seeking consent for and what the activity status is and all of those other factors. But if there's some assistance or guidance in the plan to say, don't just look at this plan, look wider, look at the regional documents, look at the national documents as part of your assessment, then that can only assist applicants and the consent planners at the council processing those consents.
Thank you. And of course, there's a degree of that that's already baked into 104, Section 104 of the RMA, which has a shelf life currently. Mm-hmm. But I guess it's helpful to have that clarification that potentially some non-regulatory guidance or practical guidance may be useful. Thank you. There's a wider issue of scope that is before the panel in relation to a submission about a national policy statement, and where you've expressed us to exercise caution in how we're defining scope and also exploring potential changes within that scope. One of the submissions is before us on another matter is that a party submitted that the pending national policy statement should be reflected in revised provisions after the fact. The national policy statement at the time the submission was made didn't exist. Mm-hmm. And so any cross submitters, to get back to my question to you earlier, wouldn't have had the ability to substantively grapple with the outcome of that submission. So my question is, where a party has submitted in contemplation of a national policy statement and the substance of that is not known, should we proceed with caution in saying we have scope to make changes because of that submission?
I think so, because there's an element of guesswork that would have occurred by that submitter, right?
Yes.
And in terms of what the content might be and whether or not that content was is helpful or not. You know, we're looking at it in those simple terms. I mean, if the final version of the national policy statement that came through was not helpful to their position, they'd probably say, well, we dropped that
Withdraw.
submission. Yeah,
Yes.
we're not pursuing that any
Yes.
further. If it's helpful to say, well, actually, what great foresight we had, we want to pursue that with great vigour,
Yes.
because we thought it might be helpful to our cause. But the reality is I'm just not sure whether there's a great deal of weight that
Yes.
can be applied to a submission of that nature.
Yes.
Because at the time of that submission being made, the legal position was that they're suggesting something should be implemented, which couldn't have been because it didn't exist.
Yes.
So I think, again, taking some degree of caution to a submission of that nature is useful.
Thank you. And would you say there's a distinction between that scenario, and let's just take the national policy statement for natural hazards as an example. So let's say that the submitter said in contemplation of that national policy statement that the plan should be amended to give effect to it, better give effect to it, versus a submission that says the plan should be amended to take a risk-based and proportionate approach to hazards. That may provide greater scope for the panel to explore potential amendments being inherent in the objective to the NPS.
Yes.
Thank you. That's it.
And it's a topic, you know, the topic's not in any way, you know, unique to this panel and this scenario. I mean, if I give another example, because it's a live example, there's a series of mediations going on at the moment in terms of the combined plan on the West Coast. There is a national document which is due to be released before Christmas that's dealing with it's a national policy statement in terms of energy activities. The parties involved in the submissions on the and the mediation is saying, let's delay the mediation until we at least get that national document, so we can at least see what the government position is on energy activities. Everyone's agreed to that, and the timing of the Environment Court mediation is now next year, and it's going to take that into account. But we're still going to have the same issue in terms of how far can you go in that mediation, even with all those parties present, how far can you go to implement that document without running the risk that you're going too far beyond what was originally notified, because it's something new.
Yes.
And so the same type of constraint I'm saying that this panel's subject to, the parties in that mediation, or indeed the court on a consent order, or if there's a hearing, if there's no agreement, would be subject to those similar constraints as well, for the same reasons.
Thank you.
That's a useful analogy, apart from the benefit of knowing what your workflow is next year. It's really kicking the can down the road, isn't it?
Yes.
Yeah. No, thank you for that. Matt, do you have it? Okay, well, it's 11:15, we're slightly over. We'll take a 15-minute adjournment, and then Mr. Davis will come back and hear from your 5 witnesses. Mr. Brabharan, Ms. Brethren, Dr. Burbidge, Mr. Osborne, and Mr. Stevens. Dr. Stevens, sorry. Okay, back at 11:30. Welcome back, everybody. Sorry for the slight delay in reconvening. We just had a procedural matter to deal with. I understand that Dr. Stevens has a drop-dead departure time of midday, so we'll deal with Dr. Stevens first, if that's okay. Dr. Stevens, can you hear us all right? You got your ears on?
Yes, I can hear you, and I shall just go back on my video.
Good, thank you very much. Now, I take it that you haven't prepared any summary statement at all, Dr. Stevens, at all, in relation to your statement of evidence?
No, I haven't. I've only got the state of evidence that I've already been submitted.
Okay. Look, we won't, unless you want to orientate the panel in any way through a brief summary, we'll probably go straight to questions, which might be more efficient. Does that sit okay with you?
Yeah, that's fine with me. No problem.
Okay. Okay. Who wants to lead off?
Good morning. This is Commissioner Jones speaking. Welcome. I guess the first question I wanted to ask, I think I heard Mr. Davis say this morning that you might be addressing Ms. Cadis's material that she's provided last week. Is that right?
Yes, I had a look at her submission, which alerted me to something that was not included in my evidence.
Okay. Well, would you maybe just start by addressing us on that?
Yeah, sure. So, in relation to her submission, I had a look at her property and the hazard layer that was affecting her property, and I noticed that there appeared to be the medium coastal flood inundation layer was like an isolated puddle which sat across part of her property. And then I looked at other places and I realised that it wasn't one connected surface that went all the way down to the coast. So when we do the coastal inundation mapping is basically predicting the height of the sea level and matching that to the height of the land, right? And so if the land surface is lower than the predicted sea level, then that can be mapped being potentially affected by coastal inundation. Now, it's common practice that we will supply the council with two data layers. One would be all of the land areas that are lower than the sea. And then the other layer we would commonly provide is we would take out all the isolated puddles, so to call them, and we would only have the part of the area that was connected by an overland flow pathway from the sea after a period of sea level rise as well. And so the reason it wasn't obvious to me at first is because the layers in the viewer are quite hard to see, so I didn't pick it up when I was first going through the layer. So anyway, I discussed it with Stephen, and I would say that my recommendation would probably be to use a coastal inundation layer that didn't have the isolated puddles, and only the areas connected to the sea. Now that would mean that that particular property would no longer be marked as potentially affected by coastal inundation at the medium hazard level. And it would also affect some other properties as well.
Okay, I'm looking at an aerial photograph with that layer turned on. And I see, as you described them, the puddles. I see them also at the neighboring side at 299, both at the front and the rear of the house. And the one at the rear of the house is contiguous with another puddle that flows into 305 across a larger area, and also onto the southern side of the house itself. So would those be other examples where you would recommend the removal of those overlay examples?
Yes, correct.
Okay. So there could be quite a few of these, is that what I'm surmising?
That's, yeah, there would be quite a few, I would think.
Bear with me for 1 second. I might just ask the chair a question about procedure. I think we're probably just going to park that discussion there rather than look at other examples. And I think the panel is going to be adopting the same practice as with previous hearings where we have specific questions that we'd like the council reporting team to come back to us on.
Just if I can just add to that, there's some similarity with the situation you've described, Dr. Stevens, with these coastal inundation puddles, with what Mr. Osborne has identified in terms of some remnant, I don't know if it was ponding or overland stream pass, but that he's recommended should be removed and Mr. Davis has agreed with. So we'll deal with both of those matters together. But that's something that we can update the submitter on tomorrow when she presents to us.
But just so that we're clear, when she does appear before us tomorrow, your recommendation in respect of 297 is that the coastal overlay be removed altogether?
Yes, based on what I can see of that, correct.
Thank you. I just wanted to ask you a general question about the model as well, just one. I think it's in the tsunami evidence that we have where there's a mention of the sensitivity of the model to the assumed sea level rise figure that's adopted. Is there a similar sensitivity in the coastal inundation model to the assumed level of sea level rise?
Yes, there is. So the coastal inundation modelling is highly sensitive to the sea level rise scenario that you use. And so the work that NIWA did actually produced maps for 3 separate sea level rise scenarios, which were separated by about 40 centimetres-ish each one. And so depending which scenario you choose over the flat, low-lying land, that can have quite a big influence on the amount of land that is shown as potentially inundated. So because you're going up 40 centimetres in height, and therefore it's going a lot further inland, and then the next scenario goes up again. So that choice of sea level rise scenario is highly influential on the hazard zone that is mapped.
Okay. I think that's just a point to stress for Mr. Davis when he comes back to us on that question that I flagged earlier about the different assumptions for climate change and sea level rise. If we're dealing with 2 models that both have a high sensitivity to sea level rise and one's relying on 1 meter and one's relying on 1.59, I just think the panel really needs to have a very strong rationale for why we're adopting those 2 different metrics.
I did in my evidence, I took some time to explain the
Yes.
that rationale too, so I hope that's also so helpful. But I guess the choice of which you use ultimately to the council.
Yes, and that, sorry, I'm gonna make myself a liar. I'm gonna ask you another question about it. With other projects of a similar nature that you might be working on, is that 1.5 assumption industry standard?
Yeah, so it's not the actual, specifically the number, but it's the scenario used.
Yes, sorry.
And so depending where you are around the country, will dictate what the actual number looks like, because it includes an allowance for the vertical land motion, and vertical land motion is different in different parts of the country. So the scenario is, but the scenario that has been mapped is the one that is consistent with the Coastal Hazards Guidance of 2024. So there's table 8 in that guidance, and it stipulates, REC has recommendations around that, which scenario to use. And so in this case, the scenario is for at least 100 years from now into the future, which allows for the New Zealand Coastal Policy Statement, policies 24 and 25, which state not to avoid increasing risk over at least 100 years from now. And it also specifies the particular climate change scenario, which was the SSP 8.5 median scenario. And so that's the scenario that's been met is consistent with that guidance.
Thank you.
Sorry, could you just say what that guidance was? I just missed the name of it.
Yes, it's the give you the full name. It is the Coastal Hazards and Climate Change Guidance. It's an MFE publication 2024.
Thank you.
That document's linked in the Section 42A report.
In due course.
Kia ora. I just had a couple of questions just regarding site-specific assessments. And when might a site-specific assessment appropriately override an overlay? Are there certain trigger points that you would that would guide you for that?
That's a good question. I'm thinking about how I might address that.
Or maybe another way of putting it, what are the risks in relying heavily on site-specific assessments?
I guess in my experience, the challenge with site-specific assessments is the advantage of having a hazard overlay is that it provides a consistent basis for defining the hazard across a region, and it's a consistent metric right across the region, and it identifies the potential for hazards. Now, whether you then go to site-specific hazard assessments to develop variations around that, that's really a matter for the planning and the rules, I think. But I would say that, or I guess one of the risks is that you then have inconsistencies that may start to creep in. And so one of the advantages of a region hazard assessment is its consistency and identifying that. But I'll probably stay away from answering that specifically. Sure. I think it's more a matter of how the rules are implemented around that. And so, whereas my expertise is really is that regional coastal hazard assessment high quality and done to the right standards.
Thank you. I just had one more, just in relation to the flood modelling and the stormwater performance modelling. Is there any correlation between the two?
No, not particularly, no,
No.
because the climate change allowance in the coastal inundation relates solely to sea level rise.
Thank you.
Commissioner Musselwhite? No. Thank you, Dr. Stevens. Just a couple of matters. That reference to the MFE publication can be found at paragraph 91 of the 42A report under a footnote to that paragraph, footnote 18. And just finally, Dr. Stevens, it'd be useful if you could distill the explanation that you've given us earlier about those isolated coastal inundation puddles and the methodology, and explain why they are, for want of a bit of a term, outliers, because they're not connected in any way to the sea. That would be useful, and if you could deliver that to Mr. Davis, and he'll consider that in light of your recommendations. And I think it would be useful if we had an understanding of the quantum and of the properties affected. Obviously, it's not just the submitters, Lisa Caddis's property. It's as Commissioner Jones indicated, there's a couple of additional ones in Muritai Road that are adjoining, and no doubt there are other ones also that you'll be able to identify. Is that clear enough for you?
Yes, yep, sure, yep. So prepare something written, yep.
Thank you. Mr. Davis can indicate when he needs that, but as a general proposition, the sooner you can get that to him, the better. He'll be under a requirement to report to us within sort of 2 to 3 weeks of the close of the hearing, but we'll discuss that probably on the last day of the hearing as to a specific time frame. But while it's fresh in your mind, it would be good if you could attend to that. And that's all from us at 2 minutes to 12. We'll let you get on with your next appointment.
Thank you very much, appreciate it.
Thank you for your attendance.
Yes, bye.
Okay. Now, were we going to, who was next in the batting order? Yes, Mr. Burbidge. Thank you. Mr. Burbidge, you're online, I see. Can you hear us okay?
Yes, I can hear you.
Good.
Can you hear me okay?
We can, and we can see you now too, which is an advantage. We're probably going to adopt the same approach that we did with the previous speaker and go straight to questions of you. Albeit that, did you want to talk very briefly about the methodology that you've adopted in relation to the tsunami hazard? We heard earlier from Mr. Stevens about how the PDP approach relates to the ODP. Do you want to give us a thumbnail sketch as to how you've approached the methodology of identifying the tsunami hazard as it appears in the PDP?
Yes, so I can summarize the method that we used. So we have an offshore national tsunami hazard model, which estimates the wave height off the coast with a particular probability of exceedance that's consistent right around the country. What we did for this project for Hutt City Council was to use that model to hydrodynamically model tsunamis inundating the region, both at mean high water springs, which is a representative high tide value, and mean high water springs plus 1 meter. We then looked at the area inundated by all those scenarios and calculated a flow depth which has a particular probability of being exceeded across the region, 1 in 100, and at the different probability levels that Mr. Davis had just stated. And we provided those hazard layers to Hutt City Council to inform the PDP, the district plan.
And can you just speak to the modelling at mean high water springs plus 1 metre? What influence that?
That was already been summarised by Mr. Davis, but that was to be consistent with what Wellington City Council were doing at the same time.
Yes, and is that direction found in any national guidance similar to the guidance that Dr. Stevens referred to earlier?
Not that I'm aware for tsunamis.
So is there a paucity of guidance for tsunamis on this?
I would say so.
Thank you. And so how do we determine what's best practice? Is it what other councils are doing and have done successfully, or is it some other means?
That's definitely an approach. And as Mr. Davis summarised, that would have the advantage of being consistent across a region, particularly one like the Wellington region. The other approach to take is to be consistent within how other perils are treated within a particular region. And there's pros and cons of both approaches.
Yes.
Could you elaborate on some of those pros and cons?
It allows you to more directly compare the hazard between different perils within a particular region. However, that could mean that once you move out of the region to the neighbouring region, they have quite different hazard values and therefore treatments and mitigation methods for particular structures, just because of which particular region it happens to be in. So you get inconsistency at boundaries particularly.
And what about the intra-hazard?
Then you get inconsistencies between how hazards in this case are treating sea level rise and climate change. So some might be effectively treating a higher hazard or a higher risk than another, that sort of thing.
Thank you, Mr. Burbidge. I'll just see whether there are any further questions from my colleagues. Matt, you must. Nothing at all? No? Do you have any further? Just a moment, Mr. Burbidge. We're just collating our thoughts on this.
Sure.
Can we just talk briefly at the top of page 8 of your evidence? You talk about the ensemble of tsunami that could
Yep.
occur that you've considered.
Mm-hmm.
And you've noted at the end of that single events could be extracted from the model and likely consequences from that
Yep.
you've assessed. Is the reason why you haven't done that because there's so many potential variations within that ensemble?
No, that wasn't part of the scope of the project that we were asked to do in 2021. We can calculate the risk and impact across an ensemble of events if we know what we're calculating the risk to, buildings or something else.
How involved and difficult would that be?
It would be moderately difficult or if we're using existing modelling. However, if we're updating the hazard modelling at the same time, then it would be more computationally expensive. We also need to know exactly what we're calculating the risk to, buildings, of what type, that sort of thing.
What level of detail would you usually go into in that type of exercise? Would you be just using GIS data?
Yes, we'd be using publicly available data or the data available to a particular client if we were determining risks to their portfolio, for example. So we need to know something about what the buildings are, what they're made of, that kind of thing, in order to determine a potential impact or probability of an impact.
Okay.
So it can be, you do need another data set to go with it.
Yes.
So you basically have to ask the question, risk to what exactly?
Yes. Okay, that's fine for now. Thank you. I might have one for Stephen later.
Well, thank you, Mr. Burbidge. It seems that we've reached the end of our questions on that.
You're welcome.
If we do have any further questions, we'll pass them on to you in writing via Mr.
Yes. Thank you.
Thank you
Thank
for
you
your
very
time.
much. Bye.
Mr. Davis, are we going to Ms. Brethren now? Is it Bretherton? Who's the next witness?
I'd recommend Ms. Bretherton next.
Okay. Welcome, Ms. Bretherton. Thank you.
Thank you.
Thank you for your patience online. You can hear us okay?
I can, yeah. You can hear me fine?
Yes, very well, and
Awesome.
we can also see you also.
Oh,
Thank you for
thank
that.
you.
In relation to the fault hazard type,
Mhm.
would you like to also explain your approach to identifying that in the PDP and the methodology that you adopted?
It's possibly a question more for Dr. Litchfield, but from what I understand, there hasn't been any change to what was in the previous operative district plan, so it's literally just a carryover.
Yes, we heard that from Mr. Davis earlier. Do you happen to know the basis for the methodological basis for identifying fault hazard in the operative district plan?
I would need to double check that with Nicola and go back to that original report that will be attached to the operative district plan. But generally speaking, all of the active faults that are identified are done through a combination of aerial identification, trenching to refine where those are, and then further refinement if there's further trenching, ground truthing undertaken there, where we dig for the actual fault.
Yes, but you're suggesting, and subject to clarification from Dr. Litchfield, that there hasn't been further ground truthing or trenching undertaken since the original identification of the fault hazards in the ODP.
I would need to double check that. Whether there's been further in the Wellington area, I'm not entirely sure. I'd need to double check that. Yeah.
Okay. It seems that we might not be able to take this any further without putting some questions to Ms. Litchfield. Mr. Davis, are you in a position to give us some guidance on what the essential difference has been between the ODP and the PDP? Have there been additional lines identified in the PDP, or has it just been a straight carryover from the ODP?
So my understanding is that the PDP carries over what was in the ODP at the time of notification, which was updated in Plan Change 56.
Yes, okay. Do you happen to know or what changes occurred at Plan Change 56 to the ODP?
I'd have to look that up.
Yes, okay. Be useful to know that. I mean, no disrespect to you, Ms. Bretherton, but we're probably going to put a note to the officers to provide us with that information.
Absolutely. Yep.
Yes. I think you probably got off quite lightly today.
I feel so, yes.
I'll just check with my colleagues, though. They may have some residual questions, Matt. Yes, ma'am. Yes, yeah. This is Commissioner Muskrat.
Just a quick question. You may be able to answer this. I'm just wondering, in terms of the geology within Hutt City, whether how effective trenching is to identify the location of whether or not a fault trace exists within a specific site.
Again, I'd probably ask Dr. Litchfield to clarify that, but from what I understand is obviously the further something is modified, the more difficult it is to spot the trace. So if there's been extensive earthworks, for instance, or if you've got a very mobile area, it can be a little bit challenging. Or if you've got river terraces, again, it can be a bit challenging to visually identify, and then the trenching will confirm that one way or another. And from what I understand, just going back to the start of the hearing today, the further evidence has been put forward by TNT for the one particular site that wanted their site moving. Nicola has looked at that, so Dr. Litchfield has looked at that and is able to make a determination from that evidence. So I what I understand is the trenching is effective at being able to determine and refine the location, but it does require earthworks, and so it's not something that's taken everywhere for every single fault, because that would be extremely expensive.
Thank you.
Yes, thank you for that. Yes, we're hearing from that submitter, number 447, Te Kaukurera Limited, Mr. Gibson, tomorrow at 10:30. So thank you for that. Look, just for the record, and I'll leave this to Mr. Davis to organise, but we would like a statement from Dr. Litchfield explaining the differences between the ODP, particularly PC 56, and the PDP in terms of what additional, if any, fault lines were identified, fault hazard extent. And secondly, from Mr. Davis, just a reminder of how the Section 32 report dealt with that in terms of determining that that was the most appropriate approach to giving effect to the adjectives relating to natural hazards. A little bit of laziness creeping in there from us, but I haven't had a chance to read the 32 in full, but just showing those linkages, Mr. Davis, that would be useful. And that can come in through the right of reply. Thank you, Ms. Bretherton. You are free to leave.
Thank you very much.
Thank you. Okay, it leaves us with Mr. Osborne and Mr. Prabhaharan. Who's going to go first? Mr. Prabhaharan, are you good? Okay. Mr. Prabhaharan, you're dealing with the slope assessment overlay, which has attracted quite a bit of submission. Yeah, you'll be aware of the submissions of Mr. Wadham and I'm going to call it Mr. Elijah, but I may have the pronunciation wrong there. But you've provided some rebuttal evidence that we've all read. Do you want to just take us to the key points in your rebuttal evidence, just to set the scene, and then we'll ask you some specific questions in relation to that? This is the evidence dated the 13th of August that deals with those two submitters.
There's just a button on the microphone in front of you as well, if you can push that. Thank you.
Yeah, so there were two submissions which I addressed in the rebuttal evidence. One from Mr. Wadham in relation to 23 Pomari Road, and the other one in relation to the Kelsan Heights subdivision. So the key issues raised by Mr. Wadham, which I dealt with in the report or the rebuttal, is that that there has been a change in the flooding overlay and how has that affected the slope overlay. And the other one was the Natural Hazards Commission had this portal in which that property was identified as having a accepted land claim, which was found to be incorrect, and they have corrected that. And how did that affect the slope overlay? So taking those in turn, the landsliding or slope stability is affected by water, but primarily from infiltration from rain or surface runoff from land. The flooding which is in question is flooding associated with the Hutt River, which affects the floodplain on the low-lying area of the Hutt Valley, and it has no effect whatsoever on the slope in which the property is located or any other slope, and therefore that flood hazard overlay was not considered as part of our assessment of slope stability, and therefore in no way affected our assessment of slope hazard and therefore the slope overlay.
Okay, so just to be clear, in your view, the removal of the flood overlay that Mr. Wadham has referred to will have no bearing on whether the property is affected by a slope assessment overlay?
Correct, and we didn't consider that flood overlay anyway in our assessment, so it had no effect. The second point related to the land damage claim apparently submitted, which wasn't accepted by the Natural Hazard Commission, and therefore, but was incorrectly, we understand from the submission, was put onto their portal, and it was brought up with the Natural Hazards Commission, and I understand that was withdrawn because they identified that that claim was not accepted, and therefore it should have not been put on the portal. So the Natural Hazard portal, which is in question, I understand was published in about August 2023, and therefore that wasn't available for us to consider when we did the slope susceptibility assessment in 2021. And therefore we had not looked at the Natural Hazard overlay, the Natural Hazard Commission's portal in assessing our slope hazard. And therefore the removal of that from that portal did not have any effect on our assessment.
We'll put some questions to you now on the situation as it affects Mr. Wadham, and then we'll deal separately after that with the Kelson Heights matter.
Yeah, sure.
Thank you for your evidence and for your rebuttal. I just wanted to come back to that question you might have heard me raise with Mr. Davis at the beginning of the day about the relationship between rainfall and the purpose of the slope stability overlay. And in particular, I'm trying to draw a relationship between, on the one hand, the pluvial and fluvial flood models and the assumptions that they've allowed for increased rainfall as a result of climate change, and the fact that your model doesn't make an assumption about rainfall rates. So the question I rephrased to Mr. Davis was, if we were to make assumptions about that, would we expect any change in the extent of the overlay? Would we expect a larger area to be affected?
Okay, maybe I can step back and explain the slope susceptibility.
Yes.
Slope failures or landsliding is caused by multiple possible triggers.
Yes.
One of that is rainfall and associated water.
Yes.
And the second thing is earthquakes.
Yes.
Can also trigger landsliding. So it is not a single trigger hazard, but which can be affected by different triggers. The other complexity of that is the rainfall, a particular rainfall event doesn't affect slope stability in isolation, because the slope stability depends on what's called antecedent conditions. In other words, what has been the rainfall and groundwater conditions over the previous months, and
Yes.
And therefore, for example, you could have had a wet winter period, and quite a modest rainfall event might trigger slope failures. And in other cases, you might have had a dry period, and then a severe rainfall can affect
Yes.
it. The other complication is sometimes in very dry periods, you could get cracking of the ground, which allows more water to infiltrate and therefore trigger slope failure. So it is a fairly complex
Yes.
matter in terms of what triggers a landslide. The other thing is you mentioned about climate change, right? Often, a lot of the assessments with climate change are based on, say, like what's published by MFE, for example, is based on what changes in average rainfall you can expect due to climate change. And some areas you can expect lesser rainfall, and some areas you can expect more rainfall. And generally, if you look at those assessments, they are kind of fairly modest, if you like, 5, 10, 15% increase. But what really affects landsliding and slope failure is extreme rainfall events. And those extreme rainfall events, we can see, if we just think about what's happened in New Zealand, as well as overseas over the last decade, we have had a lot more frequent or more severe rainfall events. And that is a little bit of a changing thing, because a lot of the rainfall return periods are based on what has been observed in the past, whereas if climate change is happening, then that is changing what has happened in the past. So because of these complexities, the slope susceptibility has been based on not the trigger events, but how likely is the land likely to experience slope failure if there was a trigger event, either due to earthquake or rainfall, and any increase in rainfall due to climatic changes and increased rainfall events. So what we identify is the susceptibility of the land to slope failure, and we assessed it from a scale of very low to very high, and then use that as a basis for coming up with a slope overlay. The other complexity of the slope hazard is that it is not just the slope which is vulnerable to failure, which affects the land, because once the slope, for example, if you had a steep slope which fails, and it is deposited further down the slope or on flatter ground, and it could run out over a distance. So you have run out. The other thing is when you have a slope failure on steep ground, you end up with a potentially steeper slope, which can then regrade back further up the slope. So it is a fairly complex phenomenon, which you can't kind of, I'm not trying to compare with flooding, but generally, if you like say flooding, you say, okay, this is the level of flooding, and therefore this is the land affected, whereas slope failure is a lot more complex than that. And that is why the slope assessment overlay identifies areas which could potentially be affected by slope failure, and has it as a trigger for to inform landowners that there could be a slope hazard on their land, which helps them to take that into account if they are looking at further development. Upfront, it provides that upfront information so that they can look at that. And then if we look at the NPS natural hazards published late last year, which was after the event of our assessment, but it proposes a risk-based approach. And that risk-based approach can only be done on a site-specific basis based on what is the susceptibility, what is the potential trigger events, and therefore what is the risk to the development proposed or being considered. So hence the slope overlay provides a basis for informing the potential for landsliding, which can then be assessed on a site-specific basis when somebody is looking at development.
Thank you. I want to come back to that very point in the context of the Kelson Heights proposal. But to stay with this particular point, and to come back to the point you made before about the lack of any relationship between the flood overlay and the likelihood of slope stability issues arising. In Appendix B to the WSP slope failure susceptibility study, there's recorded examples of slope failure and other hazards over a long period. I can't remember how far back it dates, but it dates back several decades. I'm just wondering how difficult of an exercise it would be to geolocate where those incidents occurred, where it was a landslide or slope failure, and whether there was any spatial relationship with overland flow paths, ponding areas, etc. Would that be reasonably easy to do?
Yeah, I mean, I think we did look at, we compiled all the known slope failure instances when we started that study, and that is presented in our slope susceptibility report. So we did use that information to inform our assessment. The flooding on the river floodplain is different from what rainfall falls on the slopes and any localized runoff you get on the slopes. I mean, for example, if there are flow paths on the slope and gullies that might concentrate the flow and I guess contribute to failures more than if it was just a flat area.
Yes, I guess I'm more wondering whether it would be a helpful practical exercise to go back and look at each of those examples that are in Appendix B, and where there's been clear evidence of landslides or slips or other slope stability issues, whether those could be geolocated, if the records are that detailed, and then whether a comparison between that site condition could be made with the flood maps. Because what we have in front of us is a submitter who said that there is a relationship, or there appears to be a relationship, and I'm interested to know whether there's been any coincidence of surface flooding and slope instability, so that we can then comment on that in the context of the submission. So is that something that could be done?
Yeah, absolutely. I mean, I think we already have all those landslides geolocated and on the map, so that that is in the report, but we can provide that.
That would be helpful.
In the format, yeah.
Thank you.
Yeah.
As I say, I think the point you made about the MPS risk assessment and the fact that that's driving you towards a site-specific assessment, I think that's something that I'll just revisit with the Kelson Height example, but that's been very helpful for Mr. Wadham's submission, at least for me, so thank you.
Commissioner Jones, Commissioner Burge, Commissioner Muskrat. Okay. Mr. Brabharan, I have one question, and I apologise if it sounds overly simplistic. You're very clear that susceptibility to slope failure sits outside flooding assessment matters. What I'm particularly wanting to understand is what is the key factor for susceptibility to slope failure? Is it slope angle? And if so, what has been the key tool in assessing that? Is it the LiDAR-based data that has been used?
Yeah, I mean, we considered a number of factors, but the key factors are slope angle and the geology.
Sorry, I missed the last one, slope?
The geology, the soil,
Yes.
the type of soil or rock.
Okay.
So those are the dominant ones
Yes.
which influence that.
Soil type.
And so to look at the slope angles, yes, we used what's called the DEM, the digital elevation model from LiDAR surveys.
Yes. And yes, and then you overlay that with the soil type, and the combination of particular soil types and particular slope angles will lead to differences in susceptibility, presumably.
Correct, yeah.
Yes.
And plus a number of other factors which are listed in the report, but they are.
They're the two key ones.
Those two are the key ones.
Yes, okay, thank you. And did you say that, I think I read that that exercise was undertaken in 2021?
Correct.
Yes.
Yeah.
What's the likelihood of the situation on the ground having changed since then at a district-wide level?
Yeah, so locally, where there have been subdivisions, would have changed, and that comes to that next one.
It does.
Kelson.
Yes.
But say like in terms of the other most of the other areas, including the 23 Pomari Road, is unlikely to have changed significantly.
Okay, so the slopes assessment overlay is a trigger that there's a degree of susceptibility in the land because of the combination of slope angle and soil type. Does the, Mr. Davis, does the slope assessment overlay distinguish between low, medium and high?
That data is available in the maps behind it. In the
plan?
In the plan itself, no, because
just an
there's,
overlay.
There's only one thing that happens when you're in the overlay, so there's no need to distinguish it.
Yep, no, that's good. I just wondered whether there was a correlation between steeper slope angles and increased risk, but obviously not.
Sorry, just to clarify that, Commissioner, the slopes susceptibility study was done in 2021, and subsequently we did a slope run-out assessment in 2024, and then we used both of those as well as slope angle to come up with that overlay.
Okay, understood.
And in considering the overlay, we looked at moderate and higher slope susceptibility to be included in the overlay and generally exclude areas of lower susceptibility.
Yes, okay. So when there's a property within the slope assessment overlay and it triggers presumably an earthworks rule, Mr. Davis?
Yes, it'll trigger either an earthworks rule governing earthworks to create a new building platform on the site, or a subdivision rule governing subdivision that creates a new building platform on the site with the overlay.
And is it generally a restricted discretionary activity? Or?
Yes.
Yeah, okay. And the stipulated matters of discretion in the plan that are to be considered, presumably?
Yes, I don't know if those are off the top of my head, but I mean, it's going to tell you to look at that.
And certain information required from the applicant at both the subdivision and land use stage?
I don't know off the top of my head whether there's information requirements for those rules, sorry.
Okay. I mean, if you were assessing an application, Mr. Brabraham, that came in, let's say a subdivision consent, what sort of information, that was within the overlay, what sort of information, because the overlay would have indicated that it's got a broad susceptibility, what sort of information would you require from the applicant to give you some comfort that that the building platform was appropriate or the land use was appropriate?
Yeah, so I would expect they have a geotechnical assessment which considers the landform, the potential for slope failure on a site-specific basis based on the actual contours on that particular site. And in some cases, they might need to do some investigations depending on the type of development proposed.
Yes. And the findings of those investigations and assessments would be mirrored in any conditions of consent that would require certain things to occur, possibly before a building consent was issued.
So then they would use the natural hazards NPS approach to look at the risk associated with that land based on the susceptibility, the trigger events, and the type of development proposed.
Yes.
And therefore, what is the risk to that development?
Yes.
And therefore, either avoid those areas or they could carry out mitigation measures.
Yes.
When I say avoid, there might be a property and that might form the basis for where they site their development, if you like.
Sure.
Might want to site it further up the hill rather than on the slope.
Yeah. Okay, I'm getting the picture very clearly. Thank you for that. And this is going to be a nice segue into the Kelson Heights, issue, which potentially had a specific site assessment associated with the subdivision, but we'll get onto that in a minute. Nothing further on Mr. Wadham's? Right. Do you want to take the lead on the Kelson Heights matter, and then we'll come in with some questions?
Yeah, sure. Yeah. So in relation to Kelson Heights, obviously, there has been some development happening on that site before our assessment in 2021 and since our assessment in 2021. I understand from the submission it is continuing because it's being done in a number of stages. So in some ways, it's a kind of a moving beast, if you like, in terms of the landform is changing in that area. And landform in terms of slopes and what's done has a significant impact on slope failure susceptibility. So the submission says that modify the slope overlay to exclude all the lots in the subdivision. Now, as I mentioned before, the lots might be on flat land, but it has slopes adjacent to it, either below or above, which can impact on those lots. And therefore, it is difficult to just say those lots have been developed and therefore there's no susceptibility in those areas. The other issue is that in terms of earthquake hazards, for example, the earthquake hazard knowledge has changed significantly over the last several years. And I had a quick look at the report provided with that, and the hazard now in the National Seismic Hazard Model is much higher than what appears to have been used in that. And therefore, some of the developments as part of that subdivision development might experience slope failure or displacement, for example, in a design earthquake. And that's why a site-specific assessment, when someone actually builds on that lots, is appropriate so that they can consider these factors. There's also one of the other submissions, which is just downhill of that subdivision, where that submitter has claimed that allowing that subdivision has increased slope failure on their property, if you like. So, and I haven't looked at to see why or what happened, but whether it is a permanent feature which caused that or whether it was some temporary feature during construction of that subdivision. But it just highlights the fact that there is a subdivision developed doesn't automatically mean that there is no slope failure hazard. But I acknowledge that the landform has changed, so, and it's continuing to change. So it is also a matter for council to consider when the different changes might need to be taken into account or not, if you like. Because obviously, in the middle of the subdivision, where it is flat and not close to the slopes, there might not be the slope hazard, but that is going into a more detailed site-specific basis as well. So,
getting a little bit out of my expertise here, but let me just see if I understand what you're saying, that in relation to the Kelson Heights property, whilst most of the land is flat and it's being considered in terms of geotechnical suitability at the subdivision stage, the adjoining properties, particularly the slopes above and adjacent, do have susceptibility to slope failure. And to borrow from, to borrow from Mr. Osborne's terminology, there would be a displacement type effect onto the submitter's property, potential displacement effect that means it should be continued to be shown as affected by the slope assessment overlay. Is that too simplified?
Yeah, no, that's fine. That's
okay.
In simple terms, that's correct.
Okay. Okay. Right. Do you want to take over?
Thank you for that. I guess the point that I think probably Commissioner McMahon and I are both trying to hone in on here is it's all about efficiency and effectiveness and the general nature of the provisions versus the site-specific solution that it's driving towards ultimately. And the submitter has basically presented us with a bundle of information to suggest that they've done at least part of the assessment now, if not all of it. So I guess there's a detail question for you, and then there's a process question, which is possibly a combination of a response from you and Mr. Davis. With the detail question, I'm just interested to know if you've looked at the consented documentation that's been prepared for the completed stages, inclusive of the final earthworks plans and the geotechnical reports that have been commissioned. Have you looked at all of those for that particular area?
I have looked at them, but not in very much detail, but I've perused through that information.
Okay.
Yeah.
Well, I'm just wondering whether, if you did look at them in detail, whether that might change some of your view on the specific detail of the assessment overlay boundary. If you were to see, for example, the geotechnical certification that was provided as a post-consent condition requirement, and you were to be satisfied based on that geotechnical completion report that the stability issue that's currently extant in the overlay as we see it from the notified plan is too conservative, then that might allow for a reduction in the overlay extent and therefore a greater efficiency in the plan overall, because that's not going to necessarily require a future assessment where you're already satisfied with the works that have been done. Is that something you could do for this particular site?
Yeah, could do, yeah.
Well, I think the submitter is inviting us to ask you to do that, and I'm inclined to ask you to do that because, as I understand it, the main function of the overlay is to trigger that site-specific assessment, and if it's already been done to a large degree or completely for an area, why does it need to be done again? That's the basic question. So. That's the process step where I think perhaps you and Mr. Davis could at least confer as relates to this specific submission once you've had a look at the detail that's been submitted. And I'll give one qualifier to that. I understand from Mr. Davis's rebuttal that there's still some question about the finished form of some of the earthworks in the future stages. So I would anticipate there'd be some allowance for that. But I'm just wondering whether there's some modification to the boundaries based on what's been completed to date.
Yeah, I mean, we could look at that. Yeah.
Okay, well, I think we'll probably include that as some directions in the minutes.
What would be useful is if you could sit in on the presentation tomorrow from Mr. Gibson and listen to his explanations and questions that we put. Sorry, do I say? Mr. Legier, yes. Yes, sorry, Mr. Legier. And, sorry, lots of names floating around. You can, and we'll formulate some specific direction to you after that, but it might be useful to have you in the room just as an observation capacity.
Yeah.
Yeah.
Can do, yeah.
Thank you. Matt?
Thank you. I'm just interested in paragraph 3.3 of your rebuttal, where you talk about similar applications in New Zealand within other district plans with the approach of the slope mapping within a district plan. Yeah, I was just wondering, do you have any examples of recent plans that include this level of mapping produced at the scale that it's been produced at a district-wide scale, but is able to be viewed and applied at a much closer level at a property-specific basis?
Yeah. Let me just look at that paragraph. Yeah, so, yeah, thank you for the question. Yeah, definitely. We have been involved in looking at this for Beer Plenty for example, Tauranga City Council. Again, the assessment was done at a district-wide level and is being used to inform, I guess, district plan management of the hazards at property level. But in both cases, the hazard hasn't been looked at a property level, but at a district level. And we have recently also done a study for Auckland Council, and they are going through a similar process at the moment with a plan change. And we are providing some input to that process as well in terms of looking at submissions. So those are kind of two recent examples of what's been happening.
Thank you. Do you know if any of those examples have made it through the plan change process to operative status? Might be a question more for Mr. Davis, but if you happen to know, that would be useful.
Yeah, I believe Tauranga has, but I just need to check that. Yeah.
Just before we let you go, Mr. Brabham, I think the Kelson Heights presentation, is it still scheduled for 2:15 tomorrow, Zaretha? Yes, 2:15. And that's an online presentation, so you're welcome to join online if that's of more ease to you. And just finally, it's a question I should have asked in relation to your rebuttal, in relation to Mr. Wadham's submission. Can I just take you to your paragraph 313 on page 4? You've acknowledged there that the submitters presented a contour snapshot based on the DEM from LINS, and which was 18 months old, but newer than the LiDAR-based data used in the slope assessment overlay. That's the factual situation. What you haven't said is what you've made of that and why you've perhaps discounted its relevance. Can you just talk to that, please?
No, I haven't discounted it as such, but I'm just saying that it is changing because we used LiDARs of a particular period, and what's been presented is a LiDAR 18 months old, and so things might have changed since, and because it's an active subdivision, it's continuing to change. So I guess if we look at the 2025 LiDAR as a basis of reviewing that, it is also out of date, if you like. That's the point I'm trying to make. Yeah.
Thank you for that. Thank you for your presentation. We'll see you or see you online tomorrow. Thank you.
Okay, thank you.
Okay, Mr. Osborne, welcome. We're close to breaking for lunch, and what we thought we might do is give you an indication of the sort of questions that we've got for you, and you can reflect on them over lunch, and we can come back and hear your answers. Is that okay with you?
Absolutely.
Before we go into that, is there anything you want to say similar to what the other presenters have done in terms of the approach to modelling on what's probably one of the more contentious hazard issues?
I don't think so, other than if I talk about modelling or models, sorry, I'm generally talking about the tool that is used to generate the maps. And that tool is kind of independent of things such as the climate change allowance or the design event that's applied. Those affect the maps and the output from the tool, but they the model itself remains the same. And so, for example, the models that were used to generate the flood hazard overlays that were put in place in Plan Change 56 are the same models that were used to generate the overlays for the PDP. We've just used a different set of input parameters.
Yes. We are starting to understand that now. Yes. We've focused on the submissions that have challenged the overlays on their properties, and there's some 12 or 15 that we particularly have identified, and Mr. Jones has agreed to take you through those at a high level, and we can come back after lunch if necessary.
I'll just do a quick blitz and then we can get more into the detail after lunch, but at least you'll have the benefit, I suppose, of knowing which ones are of particular interest. Taking a step back though, welcome and thank you for your evidence and is just a process question. You mentioned in response to some submitters that you've gone back and you look specifically at the site in question, but in others you don't specifically say that. Can you just confirm with all these submitters that are seeking site-specific changes, have you gone back and looked at every single one of those sites?
I have looked at the overlays,
Yes.
And if they have raised questions in my mind as to why they look the way that, why the zoning looks the way it does, I've
Yes.
then gone into the model
Yes.
to understand why the model was, how the model has been set up at that location to generate the output like that.
Yes.
In some cases, I've then gone, actually, I should go out on site
Yes.
because it still doesn't quite make sense, or not so much doesn't make sense, I'm not sure why it's doing that. So
Yes.
if I would then go out on site to see the lay of the land.
But in each case, you've turned your mind to the specific location.
Yes, I've
that's-
looked at,
Great.
in each case, I've looked at the property that's
Okay.
referenced in relation to
That's
the
great. Thank you.
flood hazard overlays.
One of the things I'm keen to hear you address us on is the flood hazard classification. And you've made it very clear in part 16 of your evidence that the hazard classification has been completed following the GWRC flood hazard planning guidance document.
Yes.
And now, of course, we have the National Policy Statement for National Hazards, which instead of looking at the hazard classification, it's looking at a risk classification. And we're not experts in risk and hazards and the nuances in between them. So one of the things that I'm really keen to understand are the key methodological differences there between the hazard-based classifications and the risk-based classifications. And if you like, the transferability of the low, medium, and high hazard classification in the context of the risk matrix in the NPS for, what is it? Low, moderate, high, and very high risk.
Yeah.
And this all relates to the conversation we were having with Mr. Quinn this morning and some submissions that are asking us to look more closely at the NPS and very recent changes to the RPS, which are seeking closer alignment with that risk-based approach in the NPS. So if you can just reflect on that and give us some clarity. I'm not
There's
asking you to answer
Very
on the spot.
quick answer to
Oh,
that.
okay, great.
I'm not familiar with the NPS, and
Okay.
I had wondered how to present this in the sense that I'm not a hazard scientist either.
Yes.
I'm a flood modeler. My expertise is around developing models that reflect reality as best we can.
Yes.
And so when I've talked about that classification process, it's just a process adopted through discussion, and then it's a method we follow to develop those in a way you can, I'm almost agnostic to it.
Yes.
You could give me another one and I can put the results through that and come up with a new classification.
That's helpful.
I can become familiar with the NPS, but I don't know if I'm the appropriate person for
Yes.
that discussion, sorry.
It's definitely something I think we'll need some evidence on. And I appreciate you saying it's perhaps in somebody else's lane.
Yeah.
But it's just something that's turning over in my mind because of the evidence that's been tabled by others. Okay. I guess what would be useful is you've obviously included the velocity and depth graph that's used from the Greater Wellington guidelines. The NPS has this risk matrix, which draws on likelihood and on consequence. And then you use different variables under each of those axes for the matrix, and then you derive the risk based on where you fall in that. So there's definitely not a one-to-one transferability between what you've looked at and what the risk matrix proposes. But I guess if you wouldn't mind just looking at the NPS whilst you have a brief moment at lunch.
Yeah.
And if you have any initial impressions based on the likelihood and consequence tables in the NPS, I'm sure Mr. Davis can help get you a copy of it. And just to see if you have any initial impressions about my question, that could be a useful starting point for us. And appreciate that you haven't turned your mind to it, so I'm not expecting a full expert response on that.
Excellent. Yeah. It is definitely not my lane.
Okay, thank you. One of the things I'd like you to just give us the very basic explanation on is with freeboard allowance for the low hazard category, why it's only with the low hazard and not with the medium and the high.
Yep.
So that's one thing I'd like to hear back on. And I think also we had signaled in the minute about the broad spectrum of change we might expect if we were to adopt Mr. Davis's recommendation that the less conservative climate change assumption was plugged into the model. Yeah. So if you could address us on that, just the order of magnitude change we might expect.
Yep.
Appreciating that there would be quite a lot of detail in that. That's one of the things we're keen to hear back from you on. And then I think it's probably getting into the site-specific questions. And as Commissioner McMahon said, we probably have at least sort of 12 to 15 particular sites where we just have some specific questions. But there seems to be a little enclave. I'm trying to remember the two streets in particular where there's a bit of an enclave over in the Eastern Bays.
Yes.
Yeah, around Muritai and I know I've written it down, but getting a broader sense about what's happening in the model there, just so that we understand the detail. I'll find those street references.
Just while Commissioner Jones is doing that, Mr. Osborne, we will certainly give you an opportunity to respond more fully if you need to in writing. We won't be putting undue pressure on you in the post-lunch session.
Yes.
It's often when people lose wickets. So, well, this is an important issue and we want you to be able to address it appropriately.
Yeah. I am getting there. Yeah, around Karamu and Eastbourne, Karamu Street and Orua Streets. There's a few parties around there in particular, a handful. And so I think we're just keen to understand the dynamics of what the model output's showing there, where all those submitters are concerned.
Okay. Yeah.
So that's more of a helicopter view of that particular part of the district. But I think apart from that, we can just maybe scroll through some of those site-specific examples. That's sort of the overview, really.
Excellent.
Okay,
Okay.
thanks for that.
Thank you, Commissioner Jones. It's been really useful. We'll take the adjournment now for lunch. I think we'll take 45 minutes and we'll come back just after 1:45. See you all then. Welcome back, everybody. We'll commence the afternoon session of Hearing Stream 5 on natural hazards. This morning we've heard from a variety of council staff and experts, and also from Mr. Quinn from a legal perspective. And we're dealing now with the last of the technical witnesses, Mr. Osborne from Te Aki Wai. Prior to the lunch adjournment, Mr. Osborne, we indicated that we'd come back and go through some of the site-specific matters and get your initial responses and give you an opportunity to come back in writing with anything that you wanted to follow up on. But before we do that, I just wanted to clarify a couple of things regarding your evidence in chief, if you wouldn't mind.
Absolutely.
And on page 3 on your evidence in chief at 10.1.6, you're talking about the matters that you're commenting on, and you say that you comment on the hazard classification scheme that's been applied to the results from the hydraulic modelling to develop the flood hazard overlays in the PDP. Presumably that's from a pure modelling perspective as opposed to any policy perspective.
Yes, or this is the methodology we've followed. In the sense, this is how we've developed the PDP layers practically.
Yes, yes, and you quite candidly made the point that you don't have any particular knowledge of the national policy statement on natural hazards.
Yeah,
no.
I have a tiny bit more now after lunch.
Yeah. Before we get into the site-specific matters, it might be useful if you take us to the difference between the flood hazard overlays presented in the draft strategic plan and the flood hazards in the PDP. That was the last of those matters that you were going to talk about. And I'm just scrolling through what page that starts on. Section 16.
Yes.
Would you like to take us through that just to set the context?
Absolutely.
Yes.
Yeah. So in 2022, when we prepared the flood hazard overlays for Plan Change 56, we had 4 models of the 6 that we now use for those were for Stokes Valley, Eastern Lower Hutt Valley floor, which is essentially on the eastern side of the river, and then Petone and half of the Western Hills and the northern portion of Wainuiomata, the Black Creek catchment.
Yes.
And those models had been developed as part of the then Wellington Water Stormwater Modelling Panel, which has undertaken a set of stormwater model building, has undertaken a stormwater model building program for the 4 metro councils that Wellington Water was part of. And that was to develop those models in a consistent way, following a consistent methodology across those 4 metro councils. So those 4 models were developed. We then also applied that the standard design event and climate change allowance approach that had been applied or is applied in the other metro councils, which is the 20% increase in rainfall and the 1 metre sea level rise. Yep. And then the hazard classification process also followed what had been developed primarily for Porirua and for Wellington City. Upper Hutt City doesn't have hazard maps of any sort in that sense. Their model output has not been classified. So it was very much a following on in the Wellington Water had developed a standard approach, and it just followed that for those 4 models that were available at the time. And that classification approach was perhaps a bit more targeted towards planning and used less of a quantitative mathematical approach, which the layers in the PDP use very much a mathematical quantitative approach, and was, I want to say, a bit more philosophical in its approach in that while there were quantitative thresholds associated with the hazard classes in the hazard overlays in the ODP. They were things like or stream corridors, which are now associated with high hazard. In the ODP layers, stream corridors are the only high hazard component of the overlays, whereas now high hazard comprises stream corridors and any locations where there are flood model results with a velocity depth threshold above a certain value. And that's similar also with the overland flow paths, though the overland flow paths in the ODP layers are developed more around, based on the model results, ensuring there is a continuous pathway for water to flow through a catchment. So with the intention being that development would not impede that pathway, or if it did, it allowed for it elsewhere. Whereas in the current PDP layers, the approach is a lot more objective and quantitative in the sense of, again, it's simply a depth and velocity threshold. Those are the differences, really.
Thank you. General questions arise? Go for it.
Just while we're right there, I know Commissioner Jones asked this earlier, but it was also on my list, was about the freeboard allowance and why it's only included in the low hazard overlay.
Primarily because it represents a residual risk, or I don't have the Greater Wellington Flood Hazard Classification document on hand, but in their classification approach, they have almost, I don't know if it's labeled residual risk. It's a possible hazard where the modelling is done assuming a clean functioning stormwater system and a specific design event. The freeboard allowance is applied to ensure, to account for the possibility of blockages and essentially a non-fully functional stormwater network, or an over-design event, in the sense that a rainfall event that is larger than the 1% AEP event. And the reason that's applying that to the low hazard, it's used primarily to set minimum floor levels, to say if you're above this level, your floor shouldn't be flooded. Whereas including it because it is the way it has been developed, is to primarily increase level and thereby extent of the flooding. And if you were to apply that in the medium hazard and high hazard categories, so much more would be pushed into those categories that is not reasonable, purely because they they work off that, the depth and velocity values. Yeah, and I could provide, it might be more useful for me to provide a written statement about it, if that would be useful, just because it's quite technical in the sense of the way the modeling is done also makes the output inappropriate for applying that hazard classification on those results. Yeah. And, yeah.
Certainly encourage you to do that in writing and do that through Mr. Davis in the right of reply. Is there any other generic questions?
Just a quick one. Thank you, Mr. Osborne. If I heard what you were explaining correctly, the flood hazard modelling outputs identify the types of flood hazards, so overland flow paths, stream corridors, but the mapping in the district plan identifies the level of hazard. There's a low, medium, and high, rather than the actual type of hazard. Is that fair?
Yes and no. So the flood hazard modelling generates, I say theoretical, modelled depth and velocity, or expected water depths and velocities across a catchment in response to a specific rainfall event, where the flood hazard overlays then take those results and apply a specific classification approach and just separates out the different, the spatial location where specific conditions are met to be, say, a medium hazard or a high hazard. I don't know if that answers your question, sorry.
Yeah, it does. Thank you.
We'll move now on to the site-specific matters, and we're going to be focusing on your evidence. Yeah. Unless there's any preliminary matters that you wanted to respond to?
No,
Rising out of
other
your-
than highlighting a comment in section 21, issues not raised by submitters, where I have noted an error in the overlays, the PDP overlays, that doesn't include stream corridors in the high hazard, or at all, but specifically in the high hazard category across the Eastern Bays area.
Can you give us a paragraph reference there?
21.1 on page 20.
Oh, yes. Yes, okay. Mr. Davis has picked up on this issue in his I think his rebuttal.
Yeah.
If not his 42A, and suggested that there will be a scope issue in including those omissions, if you like. And if the panel was of a mind to include them, they would need to recommend a Schedule 1 plan change process for that to occur. And that seems to be accepted. Thank you for that. I'm going to hand over to Mr. Jones now to take you through some of the site-specific assessment questions that we have.
I'll go through the examples that I have, but I'll invite my my co-commissioners to jump in if there's any that they'd like to either dwell on or to go back to if I skip over them. So I was just going to run down in sequence from the beginning of part 22 of your evidence, starting with 2210 at the bottom of page 28. I'm looking at the second paragraph under that subsection where you say that you've reviewed the location of the property in the modeling and the flood hazard overlays, and note that the property is intersected by the flood hazard overlays due to the processing of flood hazard overlays to smooth them rather than modeled flooding extending onto the property.
Yes.
I guess I'm wondering, in the first instance, how common that is of an issue.
Yeah, I don't have an indication of how common that is. Okay. It would be, we could potentially work through a GIS process to establish similar conditions to what I've described there. And then the way I did it here is I looked at the property in relation to the overlays. I then went into the model. The model results are processed into the overlays through through GIS, and we smooth them because of the model representation of topography, which is made up of triangles, and so you get, I guess, triangular edges to flooding, and so the smoothing that's undertaken can result in the edges of an extent being pushed out or pulled in, depending on what the model result triangle looks like at that location. And so it is definitely possible that there are more locations across the city where this is the scenario, and there would, if required, we could undertake a process of identifying them, then going into the model results at each location, and seeing whether that sliver of impact is reasonable or not based on the model results. At the same time, we do take quite a reasonably pragmatic approach in that these layers are a trigger for a rule, and Te Aki Wai when it comes to flood modelling, we provide that information to Hutt City Council, or that in a resource consent, it comes to Te Aki Wai, the flood modelling is reviewed, and then a comment sent back in relation to it. And so we would see a situation like this most likely and say that has no bearing on where the person wants to build a house, and so it can be ignored.
Gotcha.
Yeah, so we take that pragmatic approach is if I look at this situation and I think of it in terms of what it's intended for and the rules that might apply and how they would be applied and our input to those, we might as well just remove it now because it's not going to have any bearing.
That's helpful. And so what would be involved if you were to do that GIS audit of these types of examples? How involved would that be?
Involved in terms of time?
Time.
Yeah, I'd say probably a week.
Okay.
Yeah.
But apart from that, well, I'll take a step back. If you were running or building a model using the regional guidelines, you would expect this type of issue to be extended to all models?
Yes.
The smoothing process is just part of the process.
This is an issue we encounter wherever we do the mapping, so in other metro councils as well, and across yeah, all the models.
And it shouldn't be an indicator for us that there's some gross inadequacy with the model itself.
No,
Okay.
no. It, yeah, definitely not of the model itself or of the GIS. You could challenge perhaps its use.
Yeah.
Yeah.
Well,
And
I'm just trying to
its
get it.
application.
Yeah, I'm
Yeah.
just trying to get a feel for the value in doing that
Yeah.
next level of qualification, because as you say, at the moment, if it were to reach a consent process, you might take that pragmatic approach that you said is commonly adopted, and you would say there's nothing to worry
Yeah.
about in this particular location. But equally, if it was a simple exercise and it wasn't
Yeah.
too time consuming to do that audit now to prevent X number of consents being
Would be-
required
yeah.
for no reason in the future, that's kind of the point I'm trying to drill down into.
Cool.
Yeah, jump in.
Look, I think Mr. Jones has raised quite an important point there, Mr. Osborne, that presumably you've looked at this particular property by your namesake, Fred Osborne at 13 Holmes Grove, because it's brought to your attention because it's a submitter.
Yes.
Otherwise, you probably have no reason to apply the smoothing approach.
Edit it. We apply the smoothing approach everywhere, but otherwise we would not have had
The
a
option.
reason to edit.
Yeah, to edit,
yeah,
sorry, I'll
yeah.
use the right terminology, edit, yes. And what we're trying to get a feel for is what the quantum of work would be to do this. You've indicated about a week's work to do that, yes.
Yes.
Okay, thank you, that's useful.
I'm now looking down at paragraph 2211 or part 2211. And this is one of a few of the submitters from the Manor Park area.
Yeah.
I think I might be stepping into an area that Commissioner Burge has also indicated that she's interested in asking you some questions about. So I might just get the ball rolling and she might come in and ask a better question than me. It's really related to the relationship between the GW model and what your model is focused on. And you've noted there, before you get to 2212, you say you're not able to provide comment on the GW modeling work. Just wondering if you think we should be getting any more detail from them, given it's their model and these submitters have raised these questions.
If you have specific questions in relation to things such as this, I think so.
Okay.
Yeah, because it's definitely not something I am able to provide comment on.
Sorry, so I understand you can't, you're not in a position to comment. So if I ask a question that you can't comment, you will say. But generally, I just wanted to understand, they model different areas. And so I just wanted to understand if there's any overlap of those areas. And if so, what's the influence of that? How is that reconciled?
Practically reconciled. We've simply, when we we were asked to combine the flood hazard overlay maps. They're classified in the same way, and we simply overlaid them, and wherever there was a crossover, such as this location, the higher hazard was assumed or adopted, sorry. Yeah.
So thank you.
Mr. Osborne. I actually have I have a follow-up question on the same site, or the same general area. So it looks to be, and once again, this might be a question you can't answer because it relates to the GW model. But it does look to be a site that's been recently subdivided and developed and earthworked, and I would assume that minimum floor levels and the flood hazard would have been considered as part of that, and possibly the ground levels raised. So to what extent does or could, certainly the model where you discuss the Takiwai modelling about the Western Hills, how much could that take into account the ground levels now with that mitigation, potential mitigation in place?
I'm now down into probably, I guess, the first of that Arua neighborhood that I foreshadowed before, which is down around 2217, Damon Smith. And this might be an opportune time for you to just sort of take us through the helicopter view of the dynamics of what's happening in that Eastbourne area. Yeah, and just the dynamics. It seems to me that there's this sort of central area that's running broadly northeast to southwest, where there's an increase in hazard running mid-block between Marine Parade and the toe of the hill on the eastern side. So just really trying to understand what's causing that geometry and the hazards. Yes.
Apologies. As mentioned, you have hills on one side and most likely dunes towards the coast, and you'll have a depression between the two, and that's where the water is collecting.
You see that's shown on the image now.
Yeah. And if we look at the northern end of that, even if you just go to the north slightly a little bit more, yeah, you can see it continue through the middle of this area here in that same sort of northeasterly direction. Yeah, just there is perfect. So are we, when we're looking at your combined velocity and depth indicators there, would this be more in the depth?
Yes,
area
rather
than
than velocity. That would definitely be my prediction without accessing the model results, is you're just purely because in there it's going to be deeper than 500 mils, or half a metre, sorry.
And so this is one of the examples you talked about before, where perhaps the old plan would have just been referring to this area as a
low hazard, most
low
likely.
hazard. Yeah. So this has been a big change in that respect. Yeah. Okay. Okay, that's helpful. All right. So just in the context then of that submission, 2217, you've just noted that there's an error described alongside the model report and the mapped flooding. but you don't believe it would be a material impact on the model. Could you just,
I think,
could you just come back and give us a bit of confidence
Yeah.
there that that error is not material?
yes, I think it's and I'll need to go back to the submission to remind myself what the error is. I think it's more a reference error in terms of one location or something was described in the social pinpoint, in the modelling report,
Yes.
based on the community engagement that was done via social pinpoint. One thing was described as being in one location, but
Yes.
actually it was in a different location.
Yes.
And based on my assessment of the model results, that has no impact on the use of that to confirm flooding.
Okay.
Yeah. But it was not an error in the mapping or the modelling. It was an error in terms of description or reference.
Gotcha. Thank you. I should say also that part of my motivation for asking these questions stems from the MPS, which you'll now be an expert on after your hour or 45 minutes looking at it over the break.
Yeah.
But one of the things it directs decision makers specifically to do is to make decisions based on the best information.
Right.
And so where there's any sort of indication of errors that we're potentially
Yeah.
looking at, and there's an opportunity to correct them,
Okay.
that's kind of
Yeah.
what's motivating me to explore that.
Yeah.
Okay. So you just helped. I was going to go down to 26 Ko-Fi Street in Nainai, but I think because of that explanation you've just given us from the helicopter view, it's clear that we're talking about the depth of the hazard here being the critical reason why it's in the high hazard.
Yeah.
So that's clear. Thank you. How about if we look down at 22.24 at the bottom of page 41, it's 27 Cornish Street in Korokoro. Now we're over on the other side of the harbour.
Oh, yes.
And at the top of page 42 in the second paragraph, you say the modelling generates results that fall within the high hazard category. Again, I was just looking for the detail there. Is that stream corridor or depth or velocity or the combination of the two?
At that location, it is, I would say it's a combination of both. That location, there is a stream flowing, I think, underneath the buildings through a series of culverts. It's where the Korokoro stream exits the hills and goes through the harbour.
Yes.
And so, and a lot of, it's a fast moving stream. It shifts a lot of sediment.
Yes.
And so the high hazard there would also be related to depth and velocity, but also simply the stream corridor is a individual mapped layer that is then combined into the high hazard category.
It broadens out quite a large amount there, but it also looks like it's combining with another high hazard along the railway corridor.
Right.
And even coming up possibly from the coast?
Yes, so it's probably a combination then of where it's along the railway corridor, that's probably more depth related because it's backing up. And certainly we've seen examples of, we have quite good examples of flooding in that location. And you get up to 0.5 metre of water on the motorways simply because water backs up against the median barrier. So it'll be, a combination.
Thank you. So again, if we look at 618 Marine Drive, which is starting at the bottom of page 47, and then when you get over onto page 48, you just note that there's errors in the relevant model build report, but that it doesn't have an impact on the flood hazard. Is that the same type of error as the previous one we discussed?
Apologies, I'll just.
That's all right. Take your time.
In that case, there are, I think what this submitter is referring to, it's not, it wasn't immediately clear in the report, in the submission, what exactly the errors were. I assumed it to be, there are multiple errors within the report, like grammatical errors
right,
and
okay.
broken figure links and table links that spring up as error in the report. And so that is what I took. their
Not
comments on.
fundamental errors.
Yeah, not fundamental errors associated with the modeling or the mapping.
Thank you. Okay, can we go down to the top of page 62? We're back at Muratai Road in Eastbourne now. This might actually be one that would be helpful to get up on the screen, I think. It's 438 Muratai Road. If you zoom right in, yeah, so it's this particular blue node in the middle. And what triggered my interest on this one was reading down below in the context of the Somerset submission at section 2282. You talk about how you filtered out islands like this.
Yes.
Where the area is less than 150
50,
squares.
yeah.
This, I think, looks like it might be less than 150 squares.
I can check that. So yes, it's 115. So I'm not sure why that has remained. Quite possibly, and perhaps this isn't outlined in the. This is probably something I should go back and check and provide a written comment on. It may be island. It may not be an island in the sense that there may be a stormwater network pipe associated with that location and a manhole or a sump. And so what's possibly not outlined in the methodology, the hazard classification methodology, is that islands are unconnected in the sense of also the stormwater network, because our models include the stormwater network. And I think I did review this location with the stormwater network in place, and there is a pipe connected to it. However, I can go back.
Please check that one, thank you. And would the nature of the asset that's there determine the extent of the ponding that's been modeled?
Yes, yes, if it's a larger pipe, well, yes and no. In the modeled scenario, most likely not, because very close to the coast, dealing with a very high sea level, which will restrict the network's ability to drain, and that's potentially why we're seeing spillage or surcharging there, because the water cannot get away and drain to the coast because of the high sea level. However, if an event occurred when there was not a high sea level or at a different time in the tidal cycle, it could potentially drain with the current asset in place.
Yes.
But, yeah.
Okay. Thank you. So one more piece of homework for you to come back to us on with the, just confirming that one. Page 69 and section 2256. This is in the context of 2 Cheviot Road in Lowry Bay. And you just say in the second paragraph there, considering the timing of the work described in the submission, I expect the outcomes have been included in the modeling. I cannot confirm without more details regarding the work. What would be required to confirm that?
I guess an indication of when the work occurred and then also what the actual network upgrades or additions were, so that we can match those against what's in our model. So my comments there, looking in the model, we do have network, stormwater network in the model at the locations described, but I don't know if those match what was put in place, because I don't know what was put in place. Yeah, so some description of of the assets installed or changed would be required.
Is that something that you could ask your asset management staff about?
Potentially, although I think the timing was those. Yeah, I don't know. With some digging, probably.
Well, if you could have a go at it.
Prior to the establishment of Wellington Water, and so even, whether that information sits with Hutt City Council or with Te Aki Wai, I'm not sure.
Okay.
Require.
Well, we'd appreciate your endeavors if you could have a go at it. Equally, Mr. Davis, if it was potentially a Hutt City asset and you could make inquiries here, that would also be welcome.
I think that's particularly important because I don't believe we're going to hear from the submitter on this particular one. And if there's some uncertainty, it just creates a not a very clear platform for us to make a decision on.
Okay, can we go back to Eastbourne, sorry, back to 283 Muratai Road. And this one has that nodule of medium hazard risk towards the rear of the site.
Yeah.
So this is part of that wider helicopter discussion we were having before about the different hazards. And I'm really just wondering if you can help us understand the likely cause of that particular geometry there being medium risk rather than...
There are, so this potentially relates to my earlier comment about the error with the streams.
Yep.
There is a stream that comes in close to the driveway just south of the top of the driveway, just south of 285.
Mm-hmm.
And there's some sort of inlet structure in that area. So that medium hazard zone could potentially be, was most likely due to depth, because that's is probably a fairly or a lower area than elsewhere, but there's also, because of that inlet structure, that does definitely surcharge and causes a lot of the flooding we see through there, or contributes to it. There could be a velocity component to that just in the immediate vicinity of the water coming out of that stream or surcharging the inlet structure. But I can...
If you can confirm that, that would also be great. Thank you. Similar sort of accuracy question, getting down to 72, which is relating to 192 Normandale Road.
Sorry, what was the page?
Bottom of 71 and on to the top of 72. And talk about incorrect mapping on the
Yeah.
road upstream of the property because the culvert beneath the road is not represented in the model.
Yeah.
And then you go on to say if the culvert was present in the model, it may convey all the runoff beneath the road. However, runoff would still enter the stream corridor mapped on the property, which would remain unchanged. So
Yeah.
there's no merit in your view of refining the model to get that.
No. Yeah, certainly not from the, for that property,
Yeah.
because, yeah, either the water gets to that property through the culvert or it gets to the property across the road.
Okay. Thank you. I can feel everybody's excitement levels rising. I'll try to keep the pace up. 27 Waterloo Road in Hutt Central at the top of page 75. So again, this is more that helicopter question as to what's happening to generate the medium hazard.
Yeah, in this location, it would be most likely depth because it's in a fairly broad, flat area. Rather than, I would not expect high velocities, but I'd possibly need to check that. Well, I'd probably prefer to check that before concluding.
Yeah, I think that would be useful.
Yeah.
Okay. Can we go to page 76 through to 78? This is 28 Kotati Road in Days Bay.
Yep.
Now, this is one of the examples where you've suggested that the stream corridor layer needs to be increased due to an omission, which I think, as the chair mentioned before, we have some scope issues to grapple with there, but
Yeah.
I was more interested immediately in the geometry of the high hazard layer here within the road reserve.
Yes. So that is most likely more velocity based because it's water exit. The stream corridor there is in portions and water is entering and exiting it in the model.
Okay. So even where it's in the road.
Yeah.
Okay. All right. Nearly there. I think that might be all. Yep, that's it. Any others?
Mr. Osborne, there's an opportunity for you to come back in writing on each of those. Just to confirm what you've said or to add to what you've said. In doing so, it'd be useful if you can indicate your level of confidence regarding your recommendations, particularly where you've indicated that you recommend that the flood hazard be maintained.
Okay.
Yeah.
Would it be possible to receive a list of the properties highlighted? Thank you.
Yes, we've marked them up as we've gone along. So yes, I'm sure Mr. Geard was conducting a list, and thank you for sharing those images on the screen also, Nathan, that's been useful. And we'll do that also with the submitters tomorrow and the next day too, when they're attending.
Just one more question of clarification. I asked Mr. Quinn this morning when we were talking about the particulars around possibly rerunning the model with the lesser assumption for climate change effects and the need for precision to look at the extents and how they change.
Yeah.
I'm assuming that you probably would be involved in that. But I guess my question would be, in addition to that rigid quality assurance step, would you also be going back and looking at the model as if you were looking at it anew and identifying new islands to discount, or other small changes to be made based on your normal modeling practice?
Yes, in terms of the islands, or anything in relation to the development of the flood hazard overlays, yes.
So it'd almost be like starting from scratch again.
Or for the flood hazard overlays, yes. For the models themselves, no, because again, we're simply putting in a new, in fact, we have the model results for those earlier climate change, for the lower climate change scenarios already run, because we ran them for Plan Change 56.
Right.
It was simply running them through the different hazard classification process.
Okay. But there'd still be a need to go through all those quality assurance practices once you rerun them. Okay. Thank you.
Yeah.
Sorry, thank you, Mr. Osborne. That's been very good. Thank you for your willingness to go through that in real time. But as I said, we'll have that opportunity, and we'll distill the directions to you into a written memorandum so that you can respond to that in due course.
Thank you.
There are some other larger issues that the panel need to grapple with in relation to the modelling exercise, and in particular how that translates into risk assessment and hazard assessment. So but we'll give some thought to that and come back in a minute, and that'll be of more relevance to Mr. Davis. Unless there's anything further, any matters arising? No, we'll adjourn the hearing for today. Oh, we are, of course. Sorry, Mr. Davis. Getting well ahead of myself. We won't adjourn the hearing. We'll excuse you, Mr. Osborne. And we'll return to Mr. Davis in terms of both your rebuttal and your 42A report. I'm just wondering how we might be able to do this in an effective manner. We'll just take a little pause and work through this. Hang on. Sorry about my earlier enthusiasm of finishing early.
hopes up.
We're going to try and do this on a thematic basis, Mr. Davis, but and the best way we can think of doing that is each commissioner is going to put a series of questions to you, and if there's any mopping up to do at the end of that, we'll do that, and that'll be across both the rebuttal and the 42A. We've adopted that approach because we think a lot of the questions we might have otherwise asked have already been asked, and we can always come back to you in writing if we need to. So I'm going to ask Commissioner Muspratt to start, and we'll followed by Commissioner Burge, then Commissioner Jones, and if there's anything further from me, I'll complete that.
Thank you, Mr. Davis, for your 42A report and your rebuttal. I've got thematic questions. I've tried to place them in order, but it might be a bit of a shotgun exercise, so please bear with me. We'll start with policy NHP 5, which you are recommending for deletion at the moment.
Yep.
And I was just wondering if you could, as part of your right of reply, just point to the scope for deleting that policy.
Sure.
Thank you. NHP 5. Okay, policy NHP 10. This is the policy, I guess, essentially with a carve out for residential apartments, which some submitters are quite interested in. And I was just wondering, I have read the 32, but I was just wondering if I could hear in your own words, why the carve out specifically for apartments versus other activities sensitive?
I think the general idea is that given the wide range of areas covered by the overlay, and in some cases the multiple hazards present, that some use needs to be provided for. Apartments is a more practical than many others in that residential activities can be located entirely above ground level, and for apartments can be constructed in a way that's resilient to a flood event, especially being built out of concrete or being up on columns above ground level. And of the sort of available activities that could be considered, it was one that's, I guess, likely to be taken up and lower risk potentially than some of the others that could happen in those areas. People will at least be familiar with the hazards because they live there. You're not going to have to deal with visitors or necessarily vulnerable populations who need to be evacuated. Taller buildings also have the, much more likely that people can shelter in place and find refuge in the building even if the floodwaters rise.
Okay, thank you. Yes?
Just to follow up on that same policy, I'm looking at paragraph 538 of your 42A report, where you've recommended against including any guidance on evacuation procedures at a policy level. Just wondering whether this is ever going to be considered in either a fully discretionary or non-complying activity, since activities that would be giving effect to this direction.
I mean, it would be in scope to consider them. The question and decision for you is whether policy would direct that. I don't know if it would automatically be something that would occur to people to advance a resource consent process without some sort of direction in the plan.
Yeah, sorry, I didn't ask my question very well. When you talk about an absence of matters of discretion for restricted discretionary activities, you can deal with these issues through the consent process, the evacuation process. But if these ever fell, any activities ever fell as a fully discretionary or non-complying activity.
So I'm not sure I had the right reference there. Could you tell me which paragraph this is?
I'm looking at 538. The requirement for an emergency response plan is better dealt with at resource consent stage, particularly given that this consent pathway will often apply to sites that are not currently at risk and will not become at risk for decades.
Yes.
if we're not dealing with a restricted discretionary activity category in this context, if we're ever dealing with discretionary or non-complying, would it be helpful for decision makers to have policy guidance on that particular matter to take some guidance from?
Yes, Alyssa. I'm not sure I see the connection with the activity status. I think regardless of,
In
I
a
think that
restricted
it
discretionary
shouldn't-
context, you'll have matters of discretion,
yes.
decisions will be framed a certain way. Once you go to discretionary and non-complying, you're not limited.
Yes, I mean, the fact that it's not included in the policy doesn't mean it can't be considered a resource consent if it's discretionary or non-complying. I don't think it would be very likely that anyone would consider that a practical approach in the absence of a policy directing them to consider it. Like I say, I think as an administrative matter, I don't think it is really within the capacity of the council or people following a resource consent that we would have this requirement to produce an evacuation plan now and continue following it up for decades in the future when it will be irrelevant until decades in the future.
Okay. So just summing that up, you don't think that policy direction is helpful for decision makers on that?
I think it's unhelpful. I think it should be removed.
Yes, Mr. Davis, I did have one more question on policy in HP 10, and it's about clause 6 that you're recommending be added. And I was just wondering, from an implementation perspective, what does safe vertical evacuation route look like?
So if you're evacuating a hazard event, you could either completely evacuate the area in which the hazard is happening, so head for the hills, or you could evacuate within the building you're in, go upwards to be out of the floodwater or tsunami or other event that you're trying to escape from if the building is built to withstand it. Whether or not it's practical and able to do so depends on the design of the building. Is there somewhere to go? Can you easily access it? It's not somebody else's apartment within the building. So,
Thank you. I'm going to jump to rules, if that's all right, Mr. Chair. Double back, yeah, okay. I'd like to jump to rule NHR5. This is the controlled activity rule, where Greater Wellington's raised concerns about that status. What I was wondering, so my question's, I guess, two parts, and I think it's one where I'd ask you to come back after you've given it some more thought. That's controlled activity status versus another activity status like RD, as requested by Greater Wellington. So I guess the first part of my question would be in relation to reasonable use, and how closely that is tied with controlled activity status versus another activity status like restricted discretionary. And this might be something that Mr. Quinn could provide some advice on in terms of how Section 85 has been applied by the courts upon application of reasonable use claims. So if we could have some information on that. And the second part, I guess, would be a bit more of a Section 32 evaluation of the two activity statuses in terms of cost, benefits, risks, effectiveness, but also if you look at the matters of control that are specified within that rule, how could they, I guess, realistically be conditions be imposed to achieve those in the absence of investigating where a fault is? And I think that's kind of what the submitter has raised concerns with. So if we could have more analysis on a comparison between those two activity statuses, controlled versus restricted discretionary, that would be, I think, quite useful.
yes, I have to double check this to be sure I'm not 100%, but I believe the latest evidence from the regional council is they no longer seek that activity status be changed. Are you still interested in that if the regional council is no longer seeking it?
They have. I'm still interested in the comparison
Yep.
of
Okay.
which is the most appropriate. And I will be asking the Greater Wellington expert the same question tomorrow, but obviously not to provide the assessment, but just to run a scenario.
Sure.
Sorry, Thursday. Yes, thank you, Mr. Chair. Right. If you don't mind, I'd just like to jump to the slope assessment overlay, just in general. And it's in relation to methods, and I touched on this morning with the relevant expert in terms of how it's applied elsewhere. But what I was wondering is there's a lot of opposition in submissions to this site-specific mapping and the layer at which it can be viewed and the accuracy of that when you view it close up. And I was wondering if there's any other alternative methods rather than mapping that could still achieve the relevant objectives of triggering the appropriate site-specific assessment for earthworks and subdivision, and just what those options are and how effective they might be compared to the mapping at that scale, district-wide scale.
Yeah, and that's something I'll confer with Barbara on. At a high level, the major other option is to trigger assessment based on the slope angle of earthworks. The plan also has an earthworks rule that governs earthworks over, I think, 33 degrees, which applies outside the slope assessment overlay. And there are certainly plenty of district plans, I think Upper Hutt and Wellington have a general earthworks rule with no related overlay that requires consent for earthworks on existing slope angles over 33 degrees. One thing that doesn't capture is the run out from slopes going down to the hill, or hills, shallow areas that are vulnerable above the potential slip, because it's only considering the slope angle at the location that the earthworks are happening. It also doesn't necessarily take account of differences in geology, and that's something that, yeah.
Thank you. Keeping with my theme of jumping, structures. You put forward some recommendations to exclude structures from some rules, medium and high flood hazard rules. What I'm wondering is if we apply a scenario where so not a building, but a structure like a wall is proposed within a medium or high flood hazard area, say like an overflow path, what rule or standard would capture that in terms of the effects of a wall that might not be 10 square metres in gross floor area? How is that potential diversion either onto adjacent sites or upstream? What provisions manage that potential scenario?
You'll have a look at the rules for that. There are those flooding in some areas does include a matter of discretion around the displacement of floodwaters, and so I'll double check whether there's any overlap there between the rules applied to structures. My intent would be that would still be captured where the policy direction was to consider the diversion of floodwaters, that would happen for anything that might.
Right, but if a structure is excluded from a permitted activity rule?
Sorry?
If a structure is proposed to be excluded from a relevant rule?
Yes, I'll
within
double check whether that's
yeah, thank you.
happened.
That's great. All right, just to keep you on your toes, this is about the National Grid, paragraph 180. There seems to be agreement, in general, I think, between yourself and Transpower that the mechanism within the Natural Hazards chapter that prevents the rules in the Natural Hazards chapter from applying to the National Grid is contained within the introductory text to the Natural Hazards chapter. And this might be another dual question for yourself and Mr. Quinn, does introductory text actually provide that lawful exclusion, I suppose, or should that be within rules which there's different legal weights depending on the provisions. Rules have different legal weight. Introductory text, I think it's more questionable. So, and this is a question I've asked on other hearings as well, so far in the hearing streams, is should there be, I guess the crux of my question is, should there be specific exemptions within relevant rules, or the rule table itself that points to that rather than relying on introductory text? If you could come back to us.
Yeah, we can come back to you. That's certainly something for Stephen Quinn to weigh in on. I will just note as well, from a plan usability point of view, I think if you were to take the conclusion that you need these sort of statements built into rules in every chapter to say which other chapters do and don't apply, you would want to do a thorough exercise for the whole plan, have a consistent statement in each chapter referring to every other chapter saying which do and don't apply. It would be a big exercise and would produce, I think, quite a long statement at the start of each chapter governing those provisions. The notified approach, which, as long as it does legally work, I think is better to cover these things in the how to use the plan section once, and then expect people to, use that as their guide to which bits of the plan are relevant to their application, given that it does set out a method for deciding which bits of the plan are relevant to an application.
Yeah, it's quite often tied up with defined terms as well, and not everyone reads that part of the plan very carefully. So I'll let you come back to us on that one.
No, although as always, it's a trade-off between whether you have an entire chapter of the plan that nobody reads very carefully, or whether you lengthen individual chapters that people use a lot so that they don't read the whole chapter they're referring to. That said, the natural hazards chapter is already quite long, and I'm recommending making it longer.
Okay. Maybe the way to deal with this, Mr. Davis, is to, if you've got it already, or if you haven't, we could ask Mr. Quinn about the legalness of relying on introductory text and how to use the plan as opposed to specific exemptions, and make a call on that. But your point about being consistent throughout the plan is well made.
Yes, it's sorry, also something probably to confer with other panellists who are sitting on the infrastructure stream, because it will be most directly relevant, I think, to that chapter, which is one that has a completely separate policy approach, rule structure to underlying zones and other district-wide chapters.
Yeah, there's also a little bit in the quarry zone and earthworks provisions.
Yes.
Yeah, thank you. It's probably it from that.
If we can get some legal advice on that first in terms of the legality of that approach, and we can make a call after that, something we might have to deal with in the wrap-up hearing.
Thank you. Just a couple from me. Sorry to jump all around your 42 report here, but it's just hard to work out an efficient way of doing this.
Right, I made sure the bookmarks worked in PDF.
So just in relation to Natural Hazard Objective 2 and Greater Wellington's submission, so I'm sort of looking at your paragraph 287.
287.
And I just wasn't, your response to their submission, you say it's a worthy ambition, but you don't give us a reason for and I just wanted to know, what you did actually consider about the wording regarding long-term resilience strengths to the link to the strategic direction objective CCO2. They considered that provides a link to that strategic direction objective.
Yeah, I don't think that's a particularly strong link. The strategic direction doesn't use that language. I don't think, for the most part, what plan users are going to be doing is, a consideration of whether or not what they're doing is building long-term resilience, independent of the three things above: the protection of people from loss, life and injury, reducing damage to buildings, and the protection of essential infrastructure. Implementing this chapter may well help, the community build long-term resilience to those hazard events, but that's not really the frame through which people are applying this chapter of the plan to what they're doing.
And so just, sorry, let me just flip documents here. So when you're looking at NH02, the objective, does, sorry, just let me get it in front of me. So when, does the risk in that objective, does it refer to minimising existing risk or minimising any change to risk from development?
Sorry. a moment. Just NH02.
Yes.
Yeah, I mean, I think that's, I don't know, probably like to hear further from the Regional Council about their view about this, but I think it's spelled out more in policy P2 about what that risk is and where it applies, where I've recommended accepting the Regional Council's position to describe in more detail what that risk is there.
And sorry, you're saying that it's more detail in the policy. Policy 2 would be corresponding.
Yeah. So where in the rebuttal, I'm recommending accepting the change proposed by Ms. Wheatley for the Regional Council to. I'm accepting two different pieces of relief in that rebuttal, but relevant to her point is the subdivision use or development reduces the existing and then adding and potential future risk from natural hazard to people, buildings and infrastructure. So if they think that should be reflected in the objective as well, I think I'd like to hear further from them on that.
If it's all right, can I just jump in on O2 while we're there, objective 2? And I'm looking in particular at the submission of Michael Racklin, which you discuss at paragraph 304. And what I'm interested in there is whether you think the relief that's being sought there bears some resemblance to the objective 1 in the NPSNH.
Yeah, I mean, I don't think the PDP does fully or largely implement the NPS. Obviously the NPS came out more recently and the plan was notified. In terms of the very broad idea of that objective, though, about using the risk-based proportionate approach, that is pretty comparable to what the RPS is directing about taking different approaches to low, medium, high, and more than high risk. That's not implemented through any one provision here, rather it's done through setting out different objectives for different levels of a hazard.
Yep.
And I think it certainly does so through having a higher test in NH01 for those high hazard areas rather than the low and medium, the lesser test in NH02 for the low and medium areas.
Yep.
the degree to which that lines up with the much more specific direction of the NPSNH, like I say, certainly doesn't do that completely, but in terms of compatibility with the objective, I think it's doing that.
Yeah, I guess I'm just looking specifically at the nature of the submission, which seeks the active language to be changed from minimizes to mitigating on a risk-based level, an acceptable level using a risk-based approach, which, yeah, that seems to be echoing, at least in part, Objective 1 of the NPS, and using a risk-based approach.
Yeah, and so the council's caught in quite a difficult way between the RPS and NPS, both of which are extremely directive and which don't line up with each other. So the RPS direction there is that for where you are in a medium or low area, that you otherwise otherwise avoiding, minimising or not increasing the risks from natural hazards in a way that is proportionate to the risk or hazard. So I think it's getting further away from the RPS language there, while also building in a new test about the acceptable level of risk that the plan doesn't really define or have a way for anyone to evaluate a resource consent stage, as opposed to a test that's relative to, you can compare a level of risk to some other defined level and say, well, it's less than it would have been if we'd done some other thing, or it's reduced from what it was now, or it's the minimum level of risk compatible with doing something that we have an operational need to do. I think those are tests that can probably be met without some sort of further statement in the plan about what is acceptable risk or not, which is, I think, quite a difficult exercise, not one really that the council has scope to do at this point.
Yes. Well, scope insofar as this submission sought that objective be specifically changed that way, but I guess...
I mean, scope in the sense of, I think, doing an exercise about determining what an acceptable level of risk is, I think would be a big exercise. It would need community engagement. It would need technical expertise about what the level of risk produced by these different events is, and will change over time. It's, I think, a lot more work than just changing the text in a provision. It's not, it's not something that can be done within a resource consent. It would need a much bigger process for the council to determine.
Okay, thank you.
Just one more on NH02. Is NH02 more onerous than NH01?
No, I mean, NH02 is anticipating further development happening as long as the risk from that is minimised. NH01 is saying that you must reduce or at least avoid increasing that risk. So
The existing risk. O2 doesn't talk about existing risk, it just talks about risk.
yeah, so the existing risk, O1 is telling you to not increase the existing level of risk through what you're doing. NH02 is not talking about the existing risk, it's talking about the risk of development you're doing. So you've minimised that risk that's caused by the development you're doing.
Okay. So just to have a couple more. So just in relation to NHP5, you've recommended to delete that policy, but you've retained the equivalent policy in the coastal environment. And I just wondered why that was. I have a few questions around this actually, so if we start with that one anyway.
Yeah, so the reason why I was recommending deleting the policy in response to that fuel company submission, as Commissioner Muspratt noted, I'll come back to you on the scope for that, is that there's nothing the plan can do to implement it. Natural hazard mitigation works out, in a non-coastal context, are permitted regardless of what approach they take, whether they take a green infrastructure approach or not. If they're done, by central or local government, they're permitted anyway. There's no encouragement that the plan can do. In the coastal environment, the context is different because there is a rule there that restricts hard engineering coastal hazard mitigation works, and so you can encourage that by considering in a resource consent stage about whether a green infrastructure or Mātauranga Māori approach could be incorporated into hard engineering works or done instead of those hard engineering works. So you've got a mechanism by which it can be done.
So was there higher order direction to support that policy in the beginning?
For NHP5,
Yeah.
I think you could interpret parts of the RPS that way. I think it's
I am aware of the hard engineering one in the coastal environment, so I just.
yeah, and that's in both the RPS and the NZCPS.
Yeah, yeah. So, but in terms of like green infrastructure, for want of terminology, there isn't a specific higher order direction.
Not a very directive direction.
No.
I'd have to go back and see where some of those parts of the RPS landed. I'm not
And s-
sure some of the
and s-
appeals have been resolved.
Yeah,
on
and
the
sorry,
matter.
one other thing you said there, that you can rely on conservation activity. Let me just get my paragraph. So paragraph 802, sorry, it's actually related to CE Rule 17, but we're just on this topic, so it makes sense to talk about it. Yes, so once it was talking about green infrastructure, and so it's a wide definition, that would also be thought of as a conservation activity. So I just wondered, is that something that's defined in the plan? Would have maybe a different rule structure for certain activities if they're deemed to be a conservation activity?
Yes, but I mean, conservation activity is not used in this chapter.
No.
So whether or not there exists another rule.
Yeah, I don't know, you just put it in inverted commas, so I'm just wondering.
Yeah, so I
why-
wasn't necessarily consistent about whether I quoted things versus put them in italics for those definitions.
Yeah.
But no, there is a definition. Of conservation activity in the plan.
Yeah.
And so that is included, I think, in open space zones, there are rules for
Yes.
conservation activity, which I think it would be a bad outcome for the plan to then augment that permitted activity rule in those zones with a rule that was restricting green infrastructure conducted by someone who wasn't the council,
Yeah.
in a circumstance where they would otherwise be permitted to do it.
Okay. Thank you.
Just while we're still on that policy, at 398, where you say there's no mechanism to do the encouraging that the policy seeks, how does that compare to other policies in the plan that use encourage direction? Are there there's quite a bit of other policies in the plan that are to encourage, but are they backed up by certain methods that are missing here?
That's absolutely something I'll have to come back to you on.
Okay, there's quite a lot of policies in the plan that say encourage.
Yep.
So we need to think about the plan as a whole. And I guess related to that, and thinking about the contribution that Scribe made to the RMA, rules are included, if any, and there's other methods. Just wondering whether other methods like advocacy and education and other non-regulatory methods may be used to encourage green infrastructure.
Yes, I don't think anyone has sought any other methods in this chapter. I also think the use of putting that in a plan, if it's only implemented through methods other than rules, is pretty limited. I think it can be valuable to including other methods other than rules in a plan if it's potentially some sort of overall approach that's partly implemented through rules and other methods, and you've got to consider the whole context when you're considering a resource consent about what else it's doing. But if it's all through other methods, then you're putting text in a difficult to edit legal document that doesn't have weight in the processes that process has weight in.
Be useful if you could come back on the plan cohesion point about the use of encourage and the extent to which we should expand your rationale to other provisions.
Yep.
And just doing the opposite to encourage, we might talk about discourage. For CEP 13, at your paragraph 445, I find it. So you're not in favour of using discourage, or you are,
Yes.
to be compatible with the NZCPS, but it's not consistent with the plan's terminology. In essence, is it? That would be the only time that word would be used.
I haven't checked, but I'm not aware of discourage being used anywhere else in the plan.
Yeah.
That is language that's used in the NZCPS. And as discussed, there's also places in which the word
Yes.
encourage is used.
So just thinking about policy 25, the NZCPS, it's a focus on future development rather than existing assets. Would you say that's correct?
Hang on. Might as well grab the NZCPS while you're here. No, I wouldn't agree with that. I think it applies generally to areas potentially affected by coastal hazards, whether they're existing development or new or no development at all. I think that applies either way.
Thank you. I just had a couple of questions about engagement with mana whenua for this subject. And I went back to the Section 32 report to see, what sort of happened there. And the Section 32 report said that they had engaged with mana whenua, but they didn't receive anything back. So I just want to try and get some understanding about the limitations and what sort of perhaps prevented that dialogue. The reason why I say that is because, they've got a lot of sites within areas that are, potentially hazard prone. And it was also to ascertain whether they had an opportunity to look at, how they had an opportunity to look at those in terms of their future aspirations too, like, for example, Papakainga developments, that sort of thing. So I just wanted to get an understanding about the process that you had engaging and whether it was a time frame or a capacity issue or,
Sure. I wasn't involved in this part of the plan prior to notification, so anything more on what's in the Section 32 report, I'll be having to come back to you on and check with people who are involved.
that would be helpful. I can put my questions in writing too. Thank you. No problem. Thank you.
Thank you, Liz.
Okay. Can we please start, Mr. Davis, at the bottom of page 21 of your Section 42A report?
Page 21.
This is in the context of the Winston Aggregates submission.
Yes.
And I'm looking at the last paragraph at the bottom, towards the end of paragraph 65, where you say Petone and Seaview need special treatment for hazard adaptation because they cannot be easily moved or replaced. There's significant regional economic drivers with large employment base, and they need to adapt and evolve over time. Just wondering if you think at least some of those factors could also apply to major quarries?
I think the quarry is less affected by hazards in the first place, and so it can evolve and adapt around the constraints that it has on site. As covered in Mr Osborne's evidence as well, obviously the landform changes over time, so those hazards move. And that's kind of a different situation to those big regional centres. With the big regional centres, they evolve in times of changing from one land use to potentially quite a different land use on any individual site while supporting the overall function of that, which I think is not the case for a quarry. Its regional significance depends on it continuing to be and used as a quarry, and it ceases the moment it stops being used for that purpose. And in those coastal areas, there are multiple overlapping hazards that potentially need different mitigation or incompatible mitigation measures that might not be possible to achieve on one site. For the quarry, for those existing quarries and for likely future quarries, they are not generally going to be dealing with those coastal hazards as well, at least the regionally significant quarries.
Thank you. Comparisons with Petonian Seaview aside, have you considered this submission point in the context of the NPSI and in particular policy 5 about recognizing and providing for infrastructure supporting activities?
The NPS-NH carves out infrastructure.
Yes.
Within the RMA definition of infrastructure, which is the approach to the PDP. And so infrastructure that is covered by that exclusion isn't covered by this chapter as discussed. It gets dealt with in the infrastructure chapter. Infrastructure that might be covered by the NPSI that does not fall within the RMA definition of infrastructure, the NPS-NH is still relevant too. I think you would weigh up that and both the NPSs and objectives and policies in the infrastructure chapter and objectives and policies in the natural hazards chapter to decide whether or not those hazards can be adequately mitigated while still providing for that infrastructure to continue.
Thank you. The strategic objective that's before us on this hearing, I'm looking at your recommended changes. So we could perhaps just look at the top of page 35 of your 42A report.
Yes.
And this is sort of related to that question that I asked in the context of Mr. Rackland's submission. And you've recommended the deletion of 2 acceptable levels. So that was obviously a concept at a strategic level that the plan had previously signaled was a qualifier that was worth establishing at a strategic level. So again, looking at the objective of the NPS-NH and thinking about increased risk, full stop, as a result of subdivision land use and development being avoided or minimized, whether that goes beyond the directive in the NPS-NH objective 1.
How do you mean goes
Well, this
beyond?
is correct me if I'm wrong, but in the architecture of the plan, this is an important conduit between higher order national direction and the chapter-based provisions that follow. So there's a particular focus on assimilating national direction at the strategic level. Is that fair? At least part of the role of the strategic directions?
To an extent, I wouldn't say that's the most important role of strategic directions. I think I don't think the PDP necessarily does a great job of this, but I think the primary benefit of strategic direction is being able to weigh up competing considerations from multiple parts of the plan. And for setting up things that would be considered potentially in the context of quite large private plan changes that might themselves change objectives or big rezonings and things. I don't. the ODP does do this for some things, sort of sets out as a strategic objective how parts of national direction have been given effect to. In particular, there's policies about how the NPSUD has been given, objectives setting out how the NPSUD has been given effect to. I don't think that's that valuable.
Okay.
It's certainly not something this strategic direction was intended to do. At the time it was drafted, there was no
There was no
NPS
NPS.
NH,
Yeah,
and
that's
so it
right.
wasn't a tie-up to
But
that.
there is now. So I guess
Yes.
getting back to my main question there, do you think just on plain reading is avoided or minimized in the context of risk to people, communities and property from natural hazards? Is that a stronger direction or a more stringent direction than the objective in the NPS-NH?
It's talking about increased risk is avoided or minimised with the rewording. You could have, I guess, phrased that with two sort of separate clauses talking about risk that's caused by subdivision use development being, avoided or minimised, and existing risk not being increased or being reduced in different situations. That would make it quite complicated and starting to duplicate the detail that's there in the policies in the natural hazards and coastal environments chapters. If it is stronger than the NPS-NH, the NPS-NH does allow that. It is a minimum requirement that councils are free to go further if they want, although obviously then it's your job to decide if they should. But I don't think it does so, particularly at sort of a strategic direction level where it's implicit that it's being weighed up against other considerations and other strategic directions.
Thank you. Just a common theme with questions I've asked of both yourself and Ms. Pascal in previous hearings, just to do an audit, please, of the drafting of the objectives and the policies for the consistent use of language. So in particular, I'm looking at NH03. I'm looking at the bottom of page 56 of your section, 66 of your section 42A report. And the start of objective in NH03 is using active language, provide for subdivision, as opposed to a outcome statement.
Sure.
So if you could turn your mind to that, and I think there's a few other examples along the way.
These would all be clause 16 type amendments if adopted, presumably.
Yes. Not to suggest that any substantive changing to the language is required. It's just structural.
Yep, we'll have a look.
Just wondering at paragraph 324, which is at the bottom of 67 and the top of 68, you talk about the merits of residual risk.
Yes.
Does the plan mapping have to be the only method for addressing residual risk?
I think it's the only really effective way in terms of addressing the sort of scenario that the NHC is, raising as their major issue. For, overtopping the stop banks, that's not mapped in the notified mapping because it is, we consider it to be less than 1 in a 100-year event. The stop banks are designed to, already designed to manage more than 1 in a 100-year event, and with Riverlink being complete, they should consistently handle a 1 in 440-year event. The stop banks could fail either through a over-design event or through some unexpected flaw in the construction design. But I mean, again, that's how do you predict that in a context of you're trying to design a specific event, a specific occurrence frequency. If that were to happen, the way in which it would affect the district is that places that are not mapped as being subject to hazards in the maps that we've produced would in fact be subject to a hazard. If you were to have objectives and policies and things that get considered at resource consent stage about residual risk, it wouldn't apply to that because they wouldn't trigger a resource consent because they're not within the overlays. Where you are within the overlays, you're already considering a more likely flood event that will already occur to you.
What about where you might be in a situation where you're subject to a pluvial flood risk, one of your flooding overlays, but you're also in a floodplain for a fluvial flood risk, and the natural hazards NPS directs that we should be considering residual risk of failure of the start banks, for example, in that fluvial flood situation?
Yeah, and so that will depend on whether or not there's good enough information at the time that resource consent happens to consider that. I don't think what the NHC has pointed to for the Regional Council is really usable as it is.
Yep.
It's not really flood mapping in the same sort of way as we've done it, and it doesn't, it's not up to date with the stormwater network that's modelled for the fluvial flooding, and for that matter, for the fluvial fluvial modelling provided by the Regional Council.
Yes.
That may well be improved, and so the NPS would direct you to use that in a consent that you are triggering. I think the only real impact that would have on the plan, or could have through the entire structure of what it's doing, is that you are in a medium hazard area, and then you, having incorporated this extra information, you then conclude that you probably should be at a high risk. That's something that resource consent planners will have to contend with at that time.
Yes.
I don't think there's any useful direction we can provide them now that would add anything to the job they're already being directed to do by the NPSNH, especially when we don't know what circumstances it would apply in.
Would there be sufficient discretion for those residual risks to be brought to bear in restricted discretionary activities?
Yes, and 104 directs you to consider those natural hazard risks regardless of what discretion you have in the consent.
Just at 357, where you've addressed your changes to CEO 5, again, that's just one of those drafting requests about the active language.
Sure.
Commissioner Burge just identified before, there's the retention of the green infrastructure policy in the coastal chapter, but the proposed deletion in the natural hazard chapter. It seems like there might be the reverse in respect of CEO 7. Not with wholesale deletion, but the change that's recommended in paragraph 366 of your report. I don't think you've made a corresponding change to the natural hazard equivalent in HO5. Are there any coherence issues arising there?
So the reasoning for that was that the submitter's reasoning was that it would align better with the NZCPS, so
Yep.
it's relevant to the coastal environment provision, but not necessarily the natural hazards chapter. I can have a look at whether there would be scope to extend that to natural hazards. I don't think off the top of my head there would be any coherence issues with it, but I can.
Okay, maybe
dwell
just
further
reflect
if
on
you
that, not just whether there's scope, but also if there is scope, whether there's merit in it from a coherence point of view. Or if the answer is that there's specific direction from the NZCPS that's omitted outside the coastal marine area, then that's sufficient justification, that's also fine. I'm down all the way to page 110 now. Just before you get to section 5.2.17. This is related to the slope assessment overlay. And I'm looking at paragraphs 558 and 559.
Yes.
And where you've recommended the policy being moved to the subdivision chapter, just wondering whether that's within COE of what the national planning standards allow?
I mean, yes, I think so. The provisions that, refer to it are subdivision provisions. It's governing subdivision specifically. It's
Yep.
not a general purpose policy.
Yep, so there wouldn't be a mandatory direction about policies relating to natural hazards need to be in the natural hazards chapter?
Yeah, I mean, there are some directions in the national planning standards that explicitly anticipate a conflict between directions about what chapter things should be in. So, for example, there's a specific direction that coastal hazards should be dealt with in the coastal environment chapter, even if absent that you could have interpreted as them being able to go in either that or the natural hazards chapter. I don't think off the top of my head there's one for subdivisions the same. The subdivisions in the subdivision chapter and natural hazards and the natural hazards chapter, if you're dealing with both, then it's silent on it. I can double check that though.
And just on that move of that policy, do you think there needs to be a pointer in the introduction to the natural hazards chapter?
1 second.
Sorry, just when you're ready.
Sorry, can you say that again?
Sorry. So in relation to the move of that policy 12 to the subdivision chapter, do you think there should be a pointer in the introduction for plan users?
Yes, I do. I think exactly what that says might depend on the outcome of what happens in the subdivision chapter, though.
Sure. Yes. But I mean, just in terms of some sort of pointer at this stage, in the introduction of the hazards chapter.
Yes, so the introduction as it is refers to, 1 second. Sorry, no, my mistake. There's something I thought was there that's no longer there. But yes, I do think there should be some sort of reference to how those provisions work. I think it's possibly also worth doing that for the other hazards, which all of them are also implemented in the subdivision chapter, and all of them except liquefaction are also implemented in the earthworks chapter.
Yeah.
That might be a bigger question about how those cross-references are done for rules as well, about whether it gets done and can get done in the introduction or needs to be done, if it needs to be done for rules as a heading for whether rules are, whether it should also be done as headings for objectives and policies in the same way.
Yeah, perhaps just the introduction to that chapter, but you're the expert in it,
My preference is to do these things in the introduction where possible, but so
be simpler.
get some legal advice about whether that actually works,
Yeah, okay,
which we
thank
had
you.
assumed it would.
Thank you.
Can we just stay on this one for a couple more questions of clarification on the structure? So if we relocate policy 12 to the subdivision chapter, it's got a specific direction about subdivision in the slope assessment overlay and the nature of building platforms. Just want to understand how that sits with the general direction for subdivision of land in natural hazard risk areas under sub P22. Just the relationship between those two.
I think there are submission points on that, which I haven't assessed. They're not in the 42A or scope for the stream. I think something we'll have to deal with in the subdivision stream.
Right.
You're able to hear from those submitters.
So you think there's a possible need to rationalize the content of P12, which is being relocated,
Yeah, I think it may be in scope to do so, and whether or not you should, you'll need to assess the submissions relating to it.
And you're doing the 42A report on subdivision?
I am not.
You're not? Well, how can we convey to the author of that report? This
I
might be
will convey to the
Okay,
author of
thank you. Last question of integration on this particular point. So we're moving P12 to the subdivision chapter, but there still remain several policies in the natural hazards chapter that relate to subdivision, albeit in the context of subdivision use and development.
Yeah.
So again, is there, just from a all of plan understanding and cohesion point of view, does all that subdivision direction need to be pulled out of the natural hazards chapter and put into the subdivision chapter in a duplicate provision? For consistency's sake?
I don't think it should be done if that would involve essentially duplicating a policy across both chapters.
Yeah.
I would expect, from my understanding of the structure of the subdivision chapter, that you would normally expect, most of the subdivision chapter is framed around how subdivision is modified by if you're in some sort of spatially identified area. These are things that you should also consider in this zone, or these are things you should also consider if you're in this overlay. So, whether you're within a proximity of the national grid, or whether you're in a natural hazard overlay, or whether you're within one of the, many natural environmental values or cultural heritage overlays we have, the council has since withdrawn. I would expect normally you are looking at OBS and POLs from that topic generally, and not just the ones in the subdivision chapter.
Yep.
But whether that should be tidied up or clarified or duplicated, I think, is a question for the subdivision topic in the hearing stream 7.
Possibly with a corresponding note. Okay, thank you. Just wanting to ask a question as well about a comment you make on page 129. And this is in the context of the rules now. In buildings and structures, at paragraph 617, you said you would recommend consistency with the Wellington City District Plan approach, although you're not sure if there's scope to do so. Could you just give us a bit more of an understanding about the difference between the proposed plan and the Wellington City approach that you're advocating might be a better solution?
1 second.
617. I guess.
I think I may have deleted a paragraph at some point in preparing this document that was supposed to be a callback to.
Is possibly something that you could just address in writing with a brief summary of what the Wellington City approach is, and understanding what the difference is between the notified approach and the Wellington City approach.
Yeah, I'll come back to you in writing on that. I think at one point there was a paragraph there that referred, like summarised something from Appendix B6, that regional comparison, saying what the Wellington City Plan did there, which did not survive into the final version, I guess.
Okay, thank you.
I'll come back to you on that.
And I know you've invited the submitters to present further evidence on that. I guess just reflecting on how you've summarized the scope of the various submissions relating to this topic. You've noted, for example, at paragraph 612, that the fuel companies, in relation to specific provisions, seek that rules relating to buildings and structures are more enabling of small-scale, non-habitable, etc. Structures. So I just wonder whether that might provide sufficient breadth and scope, depending on what the nature of those changes would be from Wellington City.
Yeah, so I have, generally sympathetic with the fuel company's view that the rules should not capture, particularly small, non-habitable buildings and structures. The issue is how that's implemented and whether there's scope to do it in a consistent way across the whole chapter or only on provisions
submitted.
that the fuel companies have
Yep.
identified. So there's a bit of confusion there, and I think that is addressed to some degree in the fuel companies' more recent evidence.
Yep.
But I think probably worth hearing from the fuel companies further and trying to resolve the issue and contention about how it's implemented before trying to finish that off.
Okay.
In the rebuttal, I do recommend some changes to also include a permanent activity arm based on floor area as they've requested.
Yes.
So interested to see their response to that.
Yeah, well, depending on what their evidence is it tomorrow or Thursday, Mr. Chair? Tomorrow, fuel companies? Depending on what their evidence is, and given your openness to the exercise, it might be something that we could benefit from some informal conferencing from the two of you on. Especially if you both agree that there's merit in doing it, and if you can find scope in doing it. So we'd certainly entertain that.
Yep.
Okay, thank you. I think that's all I had on the 42A report. Just very quickly check my notes on rebuttal, Mr. Chair, if you give me a moment. If there's any other questions on the 42A.
Just had one just while Commissioner Jones is doing that. So I think it was Greater Wellington or somebody requested the definition of minimise be incorporated in the plan. You're not keen on that, but you think it's because it's plain meaning is obvious, but I think that's been the case in higher order documents too, and that's why the definition has come in, because it is not always plain meaning when it comes down to working with that word. So I just wondered if you had any more comment about, whether a definition would be appropriate in the plan, and if so, what would that look like?
I haven't changed my view from the rebuttal on that. Obviously, we're still to hear from the Regional Council about their view on that.
Yeah.
The RPS does define minimise in a number of contexts. The PDP uses minimise also in a lot of contexts, some of which the RPS is relevant to and some of which it's not.
Yeah.
And so, I think to the extent you're sort of applying those precedents and experiences people had with using that word, you should also consider the flow-on effects for the rest of the plan. Even if you were to define minimise in a way that was scoped to only the natural hazards chapter, that would come with it an implication that when you're using it in other contexts, that it does mean something different to what it means in the natural hazards chapter.
Sure.
Which I think is a lot of potential complexity and risk to add to a word. Certainly, I think the definition in the original submission of the Regional Council, I don't think adds to what people's normal understanding of the word would be, even if they feel like they've needed to do that within the RPS for themselves.
Thank you.
Okay, Mr. Davis, I just have two questions on your rebuttal. The first one is on page 9, at paragraph 423. This is at the very end of your additional discussion on changes to the maps and the climate change scenario assumption. And I'm focused on your use of the language plausible and implausible in that context, with specific reference to RCP 8.5. I'm just wondering where your use of that word is coming from.
I wasn't intending to refer to some other document or policy with the use of that word. I think it's a more, fundamental point about the RMA and the direction, national and regional direction, that it is essentially directing you to treat the future effects of climate change as a given. And obviously, it is a given that there will be such effects, but you can't get from any of the national direction what those effects will be. It would certainly be possible for national or regional direction to direct you to make certain assumptions about that, which, as I say, both the RPS and NPS specifically considered and rejected the idea of doing. So it does fall to the council and us, the panel, to decide what of those scenarios is worth planning for or not. And you won't have and can't get expert evidence on that because it's not within the domain of climate science, it's not within the domain of probability. It's a prediction about the actions that future people will take and future societies and governments will take.
Thank you, that's helpful. And then the last one relates to the changes that you are recommending to NHP2 at paragraph 611.
Yes.
And this is just a question looking at future implementation of the plan and what's going to be clearest for future users, and whether the addition of and potential future to the existing risk is better than just saying the risk.
I think I agree with the Regional Council's conceptual point here that you may be taking actions now that do not reduce risk now because you are not currently at risk of a natural hazard event. You're taking actions now that will reduce what the risk will have increased to at some point in the future because of climate change, were it not for the things you're doing now, which is, I guess, a lot of things are juggling in mind at once.
But potential future risk is a big continuum.
Yes, and so you are saying in the scenario where this potential future and risk has happened because climate change has occurred in such and such a way, or some other change in risk potentially has happened because of something, then the actions you're taking now will have reduced that below what it would have been in that scenario.
Yes.
I think it's theoretically an issue that you're opening the door to what is and isn't that potential future risk, but you're doing it in the context of identified hazard maps that have an identified scenario you're planning around. And you're also doing it in the context of a lot of the uncertainty in these is not so much what will happen, but how soon it will happen. For most of those climate change scenarios, you are looking at what's going to happen in 100 years' time, and a lot of the difference in it is whether you reach a particular point in 100 years' time, or whether you reach it in 70 years' time or 50 years' time, or whether you reach it in 200 years' time and the prediction doesn't go that far, but you're obviously on a track to do it. There's, you're taking a shared socioeconomic pathway that's assuming that emissions are, not at net zero in 100 years' time. They're continuing to emit carbon, presuming the climate will continue to respond to that. It's a question of when, not if. And so, unless you're talking about a specific date in the future, I don't think it's critical to have locked in what scenario you're talking about when you're talking about potential. And like I say, you are looking at a scenario when you have a hazard mapping that is based on a specific assumption about a scenario.
Again, going back to the NPS, is it a no risk document? Does it say no increase in risk is a desired outcome?
It's directing you to take I'm sorry.
Put it this way: if you are considering a hypothetical proposal and it has a existing pre-development risk assessment as negligible based on the risk matrix, and then you run your post-development scenario back through the matrix and it has a low risk, does the NPS say that you shouldn't allow for that?
No, it's only directing you to avoid that risk where that risk is very high using the matrix in the NPSNH. Whether or not the risk is very high is not something that we can determine at plan making stage. The plan doesn't identify risks, it categorises hazards. Even if, to the extent that we have that information, none of the scenarios we've modelled would fall in that very high category in and of themselves. They might fall into very high in particular circumstances, in particular places with particular development. You'd consider that in the resource consent.
Yes.
In which case the PDP does have that avoid directive. It's telling you to assess the risk and it is telling you to avoid an increase.
Okay. Thank you.
It's been a pretty long day, Mr. Davis. I just want to finally just get a sense of where you're tracking on one of the major issues that we raised in our minute. In that minute, we acknowledged your signalling of the preference that the climate change scenario used for flood modelling be replaced with the less conservative scenario. You didn't specifically recommend changes to the flood maps, but you sought some guidance from the panel in relation to a number of matters. And the panel in their minute went back and raised some questions regarding scope, scale of change, consistency and efficacy. And you've helpfully responded to those in your paragraphs 4.4 right through to 4.23 on your rebuttal, and we've had the assistance of Mr. Quinn also on the scope matter. We made two other observations. We said that we'd like to also hear from submitters on this to the extent to which their submission allows them to comment on it. And we also are going to afford you a final right of reply on this matter to try and canvass into section 32 matter, or 32 assessment, once you've had the benefit of hearing all the evidence. But just wondering where you might be sitting at the moment after day one of the hearing in terms of having a firmer recommendation on that preference that the climate change scenario for flood modelling be rerun using the less conservative.
No change in my view at this point. I don't think there's much point in a running change in mind until we've heard from submitters. You will need to hear from all submitters before you can make such a direction. If it is to be done, there'll need to be some sort of exercise to firm up what that direction exactly is and how it's to result from what
I appreciate the decisions with us. That wasn't quite my question. It's more in terms of what you presented to us in our rebuttal. If you break it down into scope, you seem to believe that there is scope and there's no fairness issue, and to a large extent Mr. Quinn agrees with you. In terms of the scale of changes, you thought that the scale could be a reasonably high reduction, and you made the point that you need to be sure that they are all reductions and not some other outcome. In terms of the consistency and climate assumptions, you've said, well, it is what it is, really. Can't get complete consistency across all hazard types. And in terms of the, and then you talk about the need for consistency between the different authorities. So it seems to me at least that you're moving towards reaffirming that type of recommendation in your rebuttal that you made in your 42A report, although you're yet to hear from the submitters.
Yes, sure.
Yes?
Yes.
Yes, okay, thank you. Okay, I won't place any more pressure on you on that, but I just wanted to make sure I wasn't getting a misleading sense of where you're perhaps sitting at the moment.
No, sorry, no, that's a simple question with a simple answer, which is yes. I was just confused by the word move.
Asked and answered, I think. Thank you for that. No further? Okay. Okay, we'll definitely adjourn the hearing some 90 minutes later at 4 p.m. and we'll adjourn till 9:30 a.m. tomorrow morning. We'll hear from the first of the submitters.